Thank you. All right, thank you. Good evening, everyone. This is a regular meeting of the Zoning Board of Adjustment for Wednesday, June 3rd, 2026. Notice has been given in accordance with the Open Public Meetings Act by posting a copy of the notice on the first floor of the municipal building and sending a copy to the Montclair Times, Star Ledger, and Herald News. This is a public hearing in which any members of the public are welcome to attend. The meeting agenda is available on the Montclair website, as is a link to the township's YouTube channel, where the hearing can be viewed live or after the fact. The hearing is also being televised on Channel 34. I have one change to the agenda to announce tonight. Application number 2944, address 24 William Street for Dimitri Charles has been postponed to June 17th, 2026 at 7 p.m. without the need for further public notice.
Hold on a second. I thought we were going to require them to renotice.
Yes, you're right. They will renotice for either that date or
A subsequent date.
Yeah, a subsequent date.
Okay.
All right, I will do the roll call. Chair McCullough is excused. Vice Chair Simon is excused. Mr. Caulfield is excused. Ms. Harris?
Here.
Mr. Church?
Here.
Mr. Moore is excused. Ms. Grant is excused. Mr. Griffith?
Here.
Mr. Cruz?
Here.
Mr. Sullivan is here.
Here, so our chairman and vice chairman are not present tonight. We need to elect an acting chairperson for tonight's meeting. Someone should make a motion.
I will make a motion to nominate Angela.
Is there a second?
I second.
All in favor?
Aye.
Congratulations.
Thanks.
Well played.
Okay, next up is the approval of minutes, May 20, 2026.
Thank you. Does anyone have any revisions to the May 2026 minutes?
No.
All in favor?
Well, we need a motion to adopt the minutes.
I'll make a motion to adopt the minutes.
I'll second.
All in favor?
Aye.
Aye.
I have to recuse.
Abstain.
Okay.
Okay, next we have the resolution for 613 Erie Street. Does anyone have any revisions to this resolution?
And who's eligible on that resolution?
It's Mr. Griffith and Mr. Cruz.
Okay, so-
I see no changes. I'll move.
No, I have no revisions.
So that was a motion?
Yeah, it was a motion to approve the minutes as reported.
To adopt the resolution.
Yes.
All in favor?
Aye.
Recuse.
Abstain. Next, we have the resolution for 12 Montclair Avenue. Does anyone have any revisions to this resolution?
No.
A motion to adopt the resolution?
Motion to approve.
Second.
Abstain.
You vote aye.
And finally, we have the resolution for 299 Grove Street. Any revisions to this resolution?
No.
Okay. Abstain?
Abstain.
Okay, so we need a...
Aye.
Motion.
Yeah, there was a motion. We need a motion to adopt that resolution.
I'll make the motion to adopt the resolution as written.
Second.
Okay, all in favor?
Aye.
Aye.
Abstain.
Abstain.
Thank you.
Okay, our first application is 260 Park Street.
Okay, and while Mr. Tremblay's getting set, Zana, would you raise your right hand? I'm going to swear you in for all of the applications tonight. Do you swear to tell the truth in the matters pending before the board this evening?
I do.
State your name and your position with the township.
Zainab Gazmi, Assistant Planner.
All right,
Thank
Mr.
you.
Tremblay, would you give us your appearance, please?
Yes, good evening, everyone. Alan Trembulac, appearing on behalf of the applicant, 260 Park Street LLC.
All right, Mr. Tremblay, this is an interpretation of the zoning ordinance. We don't see that often.
Yeah.
Why don't you make your argument? And then I think the procedure will be, after Mr. Trembulac finishes, rather than going immediately into board questions, I know we have an attorney present here, Ms. Del Vecchio from is waving in the back there, and then any other member of the public that wishes to make a comment or ask questions will have the opportunity to do so. Then we'll turn it back to the board for questions. I'll have something to say, and then we'll take action on the application. So go ahead,
Great.
Mr. Trembulak.
Great. Thank you, Mr. Sullivan. Again, good evening, Madam Chairperson and the members of the board. So, you know, as I indicated, I represent 260 Park Street LLC, which is a limited liability company owned by my friend and client Gino DeSanti, sitting next to me. As already been indicated, this is an application for an interpretation of the Montclair zoning map, and you don't see many of these applications. However, the municipal land use law of the state of New Jersey specifically provides that zoning boards have the authority to provide interpretations of the local zoning ordinance and the zoning map. And we also have a municipal ordinance that confirms that the board has that authority. So, by way of background, I submitted a letter along with the application that we filed with the board, I think on April 17th of this year. And again, providing background as to why we filed this application. As I indicated in that letter, I represented this client, 260 Park Street LLC, in an application filed with the planning board for approvals to construct a mixed-use building, a new mixed-use building on the property located at 260 Park Street. The application to the planning board stated that the property was located in the NC neighborhood commercial zone based upon the zoning map in place at the time the application was filed and same map that's in place today. Application was reviewed by the planning department, which confirmed that the application was properly filed with the planning board, that the property was indeed located in the NC zone district, and therefore the application was processed with the planning board and proceeded to formal hearings before the planning board for a conforming legally permitted use in the NC zone. We appeared before the planning board, presented our application over the course of, I can't remember if it was 3 or 4 meetings. But during the last meeting on March 9th of this year, a planning board member raised a question regarding the zoning for this property. And that was based upon a letter that had been submitted by a member of the public, a neighbor on Park Street, providing some historical zoning maps and other information and suggesting that somewhere along the way there may have been a mistake and that this property might not be in the NC zone, but might be located in the adjoining zone district, which is the R2 zone. There was a lot of discussion regarding that matter, during which the planning board attorney made very clear to the board that the zoning map in place was controlling and that the board should rely upon the map and proceed accordingly. Was noted during that discussion, you know, that this zoning board had authority to render an official interpretation of the ordinance if that was deemed to be necessary. But the board then, and I should also say that while this discussion was taking place before the planning board, the planning board had a memo from Janice Talley, the town planner, who had reviewed the zoning maps in response to the letter that had been submitted by the neighbor. And Janice Talley's memo concluded unequivocally that this property at 260 Park Street has been zoned neighborhood commercial continuously since at least 1974, over half a century. Notwithstanding that, the planning board a majority of the planning board members, again, concluding that there was a question in their mind as to whether there may have been a mistake on the zone boundary lines somewhere in the past, decided to deny the application. We've already submitted a request for reconsideration and reopening of the hearing based upon what we believe is a very fundamental, egregious legal error. And simultaneously, we filed this application seeking an interpretation from this board as to the zoning for this property. Now, as I indicated a couple of minutes ago, the zoning map currently in place was adopted in 2022. That's the zoning map that was in effect when we filed and processed this application with the planning board. That is the only zoning map that matters here at the end of the day. That map is posted prominently in several locations on the town's website. It's relied upon by all land use professionals, attorneys, architects, engineers, anyone. That's kind of the starting point for any analysis of a land use issue. What's the zoning? What does the zoning ordinance allow for that particular zone? So, having said that, we filed this application, again, for a simple request for an interpretation by this board of the zoning map. It's a plain and simple task, really. The 2022 map is clear as can be in showing where the zone boundary line is between the NC zone and the R2 zone. And that map clearly indicates that this property is zoned NC. There's no ambiguity, there's no uncertainty in the map. It speaks for itself, as you'll see, if you haven't already seen it. And again, jumping ahead to a legal issue and sort of responding to what I think is going to be presented, the map controls, and if there was some clerical error in the past, I don't know what the appropriate remedy is for that, candidly. I don't know that this board has the ability to provide a remedy for that. But what I do know is that we're entitled to rely upon the zoning map in place at the time the application was filed, and that map is clear and unambiguous. So, having said that, I submitted a package of 3 exhibits to Zana before the meeting began, and
We're just passing them around to the board members right now, so just go through them so we can mark them.
That's exactly what I was going to. The first of the 3 exhibits is the 2022 zoning map, the full map, showing all the properties in the town and colorized with the appropriate zone designations. Now that's...
Can we just hold on one second? You got that? Okay. Jay, would you mind sharing with somebody and just allow,
I have a copy I can hand out.
you have an extra one?
I do. At least I thought I did.
Okay, so we're going to mark Exhibit A1 is the 2022 zoning map of the Township of Montclair, correct?
Correct.
Okay, and then you tell me what you want to mark
The
next.
second exhibit in that package of 3 is an enlarged or blow-up from the 2022 map. It's an excerpt showing this property at 260 Park Street.
Which one is that, Mr. Chemyak? There's one says excerpt from 2022 zoning map, one says excerpt from Township zoning viewer.
It's the first one you
Okay,
mentioned. the
so
excerpt
A2
from
is the
map.
excerpt from 2022 zoning map.
Now, I noted on that, I should note that I did add my handwritten note showing 260 Park Street.
Oh, so that includes an identifier
Right.
as to 260 Park Street. Okay?
And then the third exhibit is an excerpt, a blown-up excerpt of this property and several properties in the area. That is taken from the online zoning viewer that is posted on the town website, showing, again, the subject property and the zoning for the subject property, as well as several properties in the immediate vicinity.
All right, so it's your position, based on these documents, the 2022 map shows the subject property in the NC zone. That's based on Exhibit A1, which is the actual zoning map, Exhibit A2, which is an excerpt of the zoning map, so you can kind of get a better view of it, with you identifying the subject property. And finally, A3 is taken from the zoning viewer. I guess if you go on the website of the township and pull up the zoning map, this is what you're going to see, and that contains an identification of the subject property. And you say all three of them depicted in the NC zone.
Correct. The only other thing I would want to make sure is in the record as an exhibit would be the memo from Janice Talley dated memo to the planning board from Janice Talley dated March 3, 2026, which is attached to my letter to this board from April 17th.
Do you want your letter and the tally memo to be marked as an exhibit?
Well, you can mark the whole thing as an exhibit. Most importantly would be the tally memo.
Okay, and your correspondence, Mr. Trebulak, is dated what?
April 17, 2026.
Okay, we'll mark that as A4. Okay. Anything else?
That's all I have. I mean, I'm happy to answer any questions the board
I think,
may
why don't
have,
we
but-
defer the questions, and why don't we hear from Ms. Del Vecchio, who is representing a client, and then we'll go also if there's any members of the public. Then we'll circle back and see if there's any questions. I'll add what I think about the matter, and we'll take action on this application. All right, Ms. Del Vecchio, you waited through the entire last meeting. We're not reached, but we're finally here. So just give us your appearance and who you represent. Thank you. Okay, and thank you for pre-marking them. So we have what's being handed out, and Mr. Trembleck, you have a copy. Exhibits 01 through, is it 010?
Yes.
Okay, and I assume you want to talk about these exhibits. Okay, they are now part of the record.
You guys prefer to stand at the podium here?
As long as you're picked up on the microphone.
It'd be loud if anything. Awesome, thank you. This way. Good evening, members of the zoning board. My name is Justine Del Vecchio, and I am an attorney with Greenbaum, Rowe, Smith & Davis. Tonight, I am representing Ms. Donna Pickett as an objector to application 2969 for the property located at 260 Park Street in Montclair, and shown on the township's tax maps as Block 2503, Lot 18. I'll be referring to the property as Lot 18 for the duration of my statement. And please, if I'm speaking too quickly, please just let me know. The question before the board tonight is whether Lot 18 is located in the NC zone or the R2 zone. I will briefly discuss the legal objectives of the board and the power to interpret the zoning map and ordinances. Next, I will walk you through Mr. Einwell's document and Ms. Talley's report, along with several historical tax maps to demonstrate that Lot 18 was historically located in the R2 zone rather than the NC zone. Finally, I will present the ordinances from 2022 that last amended the zoning map to demonstrate that none of them amended the zoning map to include Lot 18 in the NC zone. Pursuant to NJSA 40:55D-70.B, the zoning board has the power to hear and decide requests for interpretation of the zoning map or ordinance. Furthermore, Section 347-4B of the Montclair zoning code states that any cases of uncertainty or disagreement as to the exact location of any zoning boundary line shall be determined by the zoning board. The historical maps are relevant to the present inquiry, as it will demonstrate that Lot 18 was always in the R2 zone. We will further show that the 3 ordinances from 2022 that amended the zoning code did not change Lot 18's zoning designation, and that the historical maps must be relied on in this situation. Please note that one of the 2022 ordinances was passed in February of 2023, but it has a 2022 designator. As part of the publicly available documents for this hearing, there were several historical maps provided. I will first turn to the document from Mr. Anthony Einwell dated March 9th, 2026, which was part of your board packet. Do you guys need me to pull a copy up on the screen? Okay. Everybody see it okay? Okay. This document is vital as it shows on the tax maps of the township that Lot 18 is
Is this
exact.
one of your marked exhibits? I'm trying to understand.
No, this was part of the board packet, so I did not mark this as my independent exhibit because it was part of the publicly available
Because he's
documents.
not here, okay?
Okay.
And, we can take judicial notice of maps that the planning department can confirm are accurate,
Mm-hmm.
okay? But I don't know where he got this, whether it was altered, what is this?
This is just the tax map, and it has his notation on it, just counting the lots in. As you can see right there, that's Lot 18, and you'll denote it's counted 12 lots in, and as I'm going to go through in my exhibits, I will do the same
Okay, so
12 lot
I
counting
think we
in.
should mark this, just so the
Okay.
record's clear. So we have a nice, neat 01 through 010, so we'll make this 011.
Okay.
And you're saying that's a planning board member, right? Isn't he? Yeah.
Correct.
Okay, so this is his, it's titled 2026-03-09, Reed 260 Park Street, PB meeting, consists of 5 pages. Okay, that's 011.
The designation counting in, this is the tax map. It just shows that it's 12 lots in from the corner of Gordonhurst. This is important as it carries through the historical map analysis. As you can see on the second page of this document, you will see he once again, and I will go through this with my maps as well, so I'm not solely relying on Mr. Einwell. It counts in 12 spaces, showing that the highlighted lot is outside. Lot 12 lots in, Lot 18, is not in the NC zone. It's actually just outside. Okay. This document also depicts that on the 1979 map, this one is the This one is the 1979 map. It shows that Lot 18 is just outside, and it is in the R2 zone. And then it also shows, again, the 1979 map, a little bit more blown up. You can see 12 lots in, which would be Lot 18, is in the R2 zone, not the NC zone. I will also point out that in this document, Mr. Einwell denotes this with annotations by counting 12 lots in, which shows that Lot 18 is in the R2 zone rather than the NC zone. This will be corroborated by the historical maps I'm about to show you. Furthermore, Mr. Einwell noted in his May 2017 email that there were errors in the zoning map present. So the present matter is not the first time that errors in the zoning map have been discovered. You can see that.
What are you referring to?
His email that accompanied the publicly available document. So he notes that, there are other errors, and I guess at some point in 2017, you'll see an email from Janice Talley right below it because he had mentioned there were errors in the zoning map. So I just point this out to show that this is not the first time an error.
Okay, that's just his assertion after
Right.
that. Okay. And
I point this out for, demonstrative purposes.
Right, and that's page 5 of what we've marked 011.
Correct.
Okay.
Okay. I would also like to note, I know that Mr. Tremulak mentioned Ms. Talley's March 3rd, 2026 report. It does go through various prior maps, which, again, I'm about to go through, but it fails to properly identify Lot 18 on each of the historical maps referenced, as I'm going to show now. My client was able to obtain several of the historical maps through OPA request 26-224, and these maps are also the same as the enlarged figures that are part of the publicly available report from Ms. Talley, with a few additional maps that I will note. The first map you see is from 1974, and it has my annotation. I have a red circle around it there.
Okay, what are we looking at? Is this part of what we marked as 011?
This is 01.
Okay, so just as you're going through this, just identify the exhibit so that the record's clear.
Okay. So you'll see I've annotated this map. It's from 1974, and I moved to enter this as Exhibit 01. If you count in 12 lots from the corner, you will see that Lot 18 falls in the R2 zone rather than the NC zone. So the second map that you will see is from 1979, and I moved to enter this as Exhibit 02.
Yeah, we're not in court, okay, so we don't need to, you can move
You
them.
know, at the end?
We've already identified, these are exhibits, I mean, subject to an objection from Mr. Chamberlain. These are exhibits that will be part of the record. Okay.
Okay. Okay, so again, I've annotated this map with a red circle to show the location of the property. Once again, if you count in 12 from the corner of Gordonhurst, Lot 18 falls just outside of the NC zone. It is in the R2 zone. This next map, I'm only including for continuity purposes. It's a very poor scan from 1986. This is 03. You can see the faded lot lines, and once again, Lot 18 is still in the R2 zone. It is not in the NC zone. I am including this for demonstrative purposes because the scan is not great. And the historical flow will be maintained in the next exhibit I bring up. Okay. The fourth map you see here is from 1998 with my annotations. It's marked as Exhibit 04 in your packet. You will see that I've annotated this once again with a red circle to show the location. And once again, if you count in 12 lots from the corner of Gordonhurst, so here over, you will see that Lot 18 falls within the R2 zone and not the NC zone. So this fifth map is from 1999. Once again, has my annotations, has the red circle there. This is Exhibit 05 in your packets. I have noted it, and again, if you count in 12 from the corner of Gordonhurst, you will see that Lot 18 falls squarely in the R2 zone and is not in the NC zone. So this sixth map here is from 2006. I obtained it from Ms. Talley's report. It's Exhibit 06 in your packets. I didn't place that highlighted mark there. That was from Ms. Talley's report and her mark. As you will see, that highlighted mark shows 12 lots in from the corner. Once again, it's in the R2 zone. It is not in the NC zone. The historical chain acknowledged in Mr. Ironwale's March 9th, 2026, this historical change, was acknowledged in Mr. Ironwale's March 9, 2026 report, in which he questioned why the map showed Lot 18 in the NC zone rather than the R2 zone, since the historical data shows it in the R2 zone. I would also like to point out one other feature that's present in all of these maps I just showed you. If you look at the tax map from Mr. Ironwale's document, and again, this is just a copy of the tax map from the city. You will see that Lot 19, right next to it, if you look at the map, you will see that Lot 19 is immediately adjacent to this trapezoid-shaped lot. If you go back through the historical maps that I just showed you, you will see that there is one lot in the NC zone, and then the R2 zone starts. It's always next to this trapezoid lot. The line denoting the NC zone runs directly between Lot 19 and 18. So 18 is R2, 19 NC. So turning to the amendment to the zoning map in 2022. According to the town's online disposition list, There were only 3 ordinances from 2022 that contributed to zoning amendments. In your packet, you will see as Exhibit 07 a copy of the meeting minutes from the Township Council from July 26, 2022. These meeting minutes contain the 2 ordinances that amended the zoning requirements in 2022. Through my Oprah request, number 26-993, I was able to obtain a signed copy of Ordinance 22-16, and you'll see that one as Exhibit 08 in your packet. That particular ordinance amended the zoning map only for a specific area near the intersection of Park Street and Portland Place, which is nowhere near Lot 18, and this amendment had no effect on Lot 18. By way of example, on the screen here, you'll see, I pulled this from 08. You will see a copy of the map that was attached. It only changed a very small area. It did not have any effect on the zoning for Lot 18. And there's no reference to rezoning for 260 Park Street or Block 2503 or Lot 18 in that ordinance. The only other thing this amendment changed was bulk requirements for certain ordinances, so the zoning map was not otherwise touched. As for Ordinance 22-17, through Oprah request 26-993, I was able to obtain a signed copy, and you'll see that as Exhibit 09. Once again, this did not amend the zoning map at all. Rather, this ordinance simply amended certain bulk requirements and permitted uses in various zones throughout town. There's no reference to rezoning for 260 Park or Block 2503, Lot 18 in this ordinance. As for Ordinance 22-27, which was the final one from 2022, I was able to obtain a signed copy of the ordinance, and you will see it as Exhibit 010. Once again, this did not amend the zoning map. Rather, this ordinance was related to permitting accessory dwelling units as an accessory use in certain residential zones. There is no reference to rezoning for 260 Park Street or Block 2503, Lot 18 in this ordinance. So there was no ordinance in 2022 that amended the zoning map that would have put this in the NC zone. As such, as shown by the historical maps and the lack of amendments in the 2022 ordinances, Lot 18 was never part of the NC zone, and Lot 18's inclusion in such district on the 2022 map is nothing more than an administrative error. The historical data clearly shows that Lot 18 was always part of the R2 zone, and there is no conclusive 2022 ordinance that shows that Lot 18 was ever properly made part of the NC zone. As such, I respectfully request that the board interpret the 2022 ordinances and that they did not amend the zoning map regarding the zoning designation of Lot 18. I would further respectfully request that based on the data presented here tonight, that the board find that Lot 18 is part of the R2 zone and is not part of the NC zone. Thank you.
So, Ms. Delvecchio, let me just try and summarize what I think you're saying through all these exhibits.
Yep.
Basically, you're saying, yes, the map in 2022 shows the property in the NC zone, but a historical review of the underlying zoning ordinances and maps, that's an error. That there was no zoning that ultimately implemented that zoning. Is that correct?
Yeah, that is correct. The 3 2022 ordinances that amended your zoning map did not amend that zoning designation, so you have to rely on the historical data, which shows it was never in that zone.
Okay.
So it was
you
not
have anything
properly
else?
amended.
Okay, thank you for your very thorough presentation. I think now if there's any member of the public that either wants to ask a question or make a statement before the board deliberates, now is the time. Okay, would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
Can you just
And-
press the push button on the mic there?
That does it?
Yeah.
Okay, and give us your name and address, please.
My name is Claire Ciliata. I live at 279 Park Street, Montclair, New Jersey, for the last 40 years. I'm standing here tonight because I love my town and I love my neighborhood. And my neighborhood is turning into a nightmare.
Okay, hold on.
let me-
No, you can't.
Okay,
and I'll
so
explain to you
let
why.
me
Hold on.
address this.
Let me just stop for 1 second. There's going to be, we don't want to hear about whether the application is good or bad in front of the
Okay.
planning board. question before the zoning board is simply an interpretation of the zone map as to whether or not it's in the NC zone. That's it.
So, after this presentation that I watched tonight, it is very, very clear to me that there is no change of zone for Lot 18, and that any change of zone denies your own laws and your own maps and your own conclusions over the last 20 years. I have no idea why the head of planning would say that that's not so, when the maps and the minutes from your meetings prove beyond any reasonable doubt that that lot is residential, always has been and always should be. Thank you.
Thank you. Anybody else? Would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
I do.
State your name and address, please.
Gerald Fierst, 259 Park Street,
Can you spell your last name?
Fierst.
Thank you.
Mr. Iannello mentioned that one of his own properties had been miszoned on that same map. So there are multiple mistakes on that, 2022 map. I'm a bit confused by why Ms. Talley, after seeing this, would say that it has been commercial since 1972, when obviously it has not been commercial. Whether it's self-interest or incompetence, she can choose. But it's obvious that that is a misstatement, not a statement of fact. And I urge you, a digital map is not a law. I urge you to follow what is both the law and the zoning law and the obvious history of that property, which has never had a commercial space, which does not have a commercial space. And, say what is in front of us. I guess that's what I have to say. Say what is in front of you.
Okay, thank you. Anybody else? Would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
I do.
State your name and address, please.
Name is Kate Albright. The address is 176 Midland Avenue. So I'm just finding it in general really disheartening in this town to see development get stalled again and again and again for things like this, which come out of the blue that we don't understand. And it's sad because we are in such a huge housing crisis and we need housing at all different levels. So
Yeah,
I
Ms.
guess
Ann.
my question is, like, what is the process for getting a map drawn? Because I heard the
Okay.
arguments about the historical things.
Right now, we're just trying to get to
That's
what
my
the
question, is
zone
like
map-
what, yeah, my
what
question
does
is.
That's the question the
Yeah.
board is considering. What does the zone map show? The
No, my question
applicant-
is, what is the process for getting a redrawing of the map?
That's a different question. Okay, that's not the question that's before us. The zoning map is adopted by ordinance by the governing body. You can go to the governing body and ask them to, you can ask them to change the zoning ordinance, change the zone map. That's not us, okay? It's very limited scope of what we're doing here tonight. It's whether or not the zone map shows the property in the NC zone.
Okay, so you don't understand the process for how it's redrawn, or?
That's not what I said, and you didn't listen.
No, I'm
okay?
trying to process it. I'm a slow processor.
Well, listen, okay?
Okay, I'm listening.
The zone map is adopted by ordinance by the governing body.
Right.
If you want to change it, you go to the governing body.
By the Montclair Council?
Yes.
Okay.
That's the governing body.
Right.
Okay? If you want to get a change to the zoning ordinance, you go to the governing body. The zoning board has nothing to do with that, okay?
Yes, I understand that.
Okay. That's the process. Would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
Yes.
State your name and address, please.
My name's Carl Nagy, and I live at 109 Buckingham Road.
I'm sorry, 109.
Buckingham. So I support this project, but my question is more specifically on zoning. When council adopts zoning maps, I think that the ordinances usually read that we hereby like adopt this zoning map. Now, if there were historical zoning maps that differed for whatever reason, and I think 2016 might have been the same as 2022. I don't have that in front of me, so if I'm wrong, like, okay. But zoning maps are shown to the public. They're a public document. It's not, when we adopt them, they're not like, we did this exact thing or this exact thing, and these are the only things we did. It's a holistic zoning map that the public can comment on, and council and all the departments comment on, and it gets adopted. And that's what happened here. And we have a zoning map that a developer relied on and planned what I thought was a thoughtful building. I live not far away. I'm there all the time. I hope this gets built. And this is one of many technicalities that that they've overcome so far. I hope they can overcome this one. But I guess my question is, when you guys adopt zoning maps, or we as a township adopt them?
Yeah, again, we don't.
This
board does not.
The council does,
Okay.
yeah. We adopt a map. We don't adopt a red line of specific changes. That might be in some of the background to it. But we adopt a map. And there's an ArcGIS map we can see. There are zoning maps that we have on file. And that's what we have to rely on when we build things. So I guess I hope to hear some of this in the discussion, but I hope we can accept this project. Thank you.
Okay, and again, we're not approving or disapproving the development application that's pending for the planning board. The planning board has taken action. They have not, as I understand it, adopted a resolution yet. There is a request for a reconsideration before that board. So the planning board will be hearing that request at some point in the future. Okay. Anybody else have any questions or statements from the public? Okay, Ms. Del Vecchio, do you have anything else before we close it?
I guess I just kind of, can I address something he said, just
Yes,
a point
yes,
of clarification?
Yes.
That gentleman mentioned that, you adopt a whole zoning map. The ordinances that I just showed you, if you had adopted an entire zoning map, it would have attached that entire zoning map as an exhibit. None of those 3 ordinances in 2022 did that. It amended specific portions of it, and there was no cover ordinance, for lack of a better term, that adopted an updated 2022 map. Just want to.
Thank you. Mr. Tremblay, do you have anything else before we close it?
Yes, I've got basically 4 points, which I'll try to be concise. My first comment in response to this historical analysis of zoning maps. This concept that's being advanced, that you can't rely upon the zoning map that's published, that's adopted by the town and published on the website, and that if you rely upon it, you're subject to somebody making this argument that says there was an administrative error somewhere in the last 50 years. It's terrifying, frightening to me, because I practice in this area, as you know. And as I said, in my opening comments, I have people call me, every day of the week, asking me, I own such and such a property, can I do this? And this is not just me, this is every lawyer, this is every architect or engineer that's contacted by a client, and you have a zoning issue. The first thing you look to, what's the zoning for this property? Well, you look, every town has an official map. You go to the official map. Montclair's is prominently on the website. You rely upon that. Putting it with respect to this particular project, this gentleman here, who's bought and sold a few properties, but sophisticated enough to know what he's doing, he looked at the zoning map when he decided to buy this property and verified that it was in the NC zone, spent a lot of money in reliance upon the zoning map that said it was in the NC zone. We filed the zoning application, went, experts, multiple hearings. I don't know how much money he spent, tens of thousands of dollars processing an application in the NC zone after the planning department reviewed it and confirmed it was in the NC zone, and also reconfirmed that, in response to Ms. Pickett's letter. I mean, Janice Talley has been the town planner for many, many years, respected throughout the state. She has no skin in the game, no dog in this fight. She did the analysis, and you saw what her conclusions are. It's just absolutely frightening to think that you can't rely upon the municipal zoning map in making decisions, you know, that you're subject to somebody coming forth like Ms. Pickett and her attorney have and done, you know, what I'm going to refer to as a limited historical, you know, review of the maps. You know, and you're subject to the possibility that there might be an administrative error and that you spend, you know, a lot of money on a property, you spend a lot of money on a development application, and then at the very end, somebody says, oh, you're wrong, sorry. You know, you've wasted the money, you shouldn't have relied upon that. It's just frightening to me, as I said. Now, having said that, specifically with respect to what Ms. Delvecchio presented, the first comment I'm going to make about counting, you know, lots on a select number of maps is you can't tell. Maybe there may 12 lots. Maybe a lot was subdivided somewhere in the 50 years. You can't really tell which lot is which on there. And counting lots, counting the number of lots, I don't think is anything that can be relied upon. That's number one. Number two, she went through and reviewed zoning maps from 1974 to 2006 and stopped there. I want to present as an additional exhibit, which I've marked as A5, the zoning map from 2016. There was no discussion of that. That zoning map, and I'm sorry I didn't realize this was going to come up because I only have one copy, but you'll see it's basically the same map as 2022. It shows this property in the NC zone just like the 2000.
Show it to Ms. Delvecchio, please.
I'm sure she's seen it, but it wasn't provided as part of her.
All right, so that'll be
analysis.
A5. That's the 2016 Montclair Township zoning map.
So I actually have something to rebut that if you guys would like to see it.
Since he
I'll let him continue though.
Yeah, you have anything else, Mr. Tremblay?
Yeah, if I could finish. And then lastly, I would just, with respect to the 2022 zoning map, I would just like to cite for the board, this is from section 347-4 of the Montclair zoning ordinance, which reads as follows, quote, "The boundaries of each of these zones created by this chapter are shown on the zoning map, Township of Montclair, as prepared by the Township Department of Planning and Community Development and amended through June 2022, which is hereby adopted and made a part of this chapter," which is hereby adopted and made a part of this chapter. In 2022, this zoning map was adopted. It's the same map that was adopted in 2016. And if you're going to do an analysis of zoning ordinances that might be relevant here, you can't pick 3 ordinances from 2022, because if there was a change in zoning, it might have taken place sometime before, in 2016 or before then or any other time in the last 50 years. The municipal land use law is very clear, and Mr. Sullivan knows this as well as anybody. The law is that applications presented for development before this board or the planning board have to be judged by the boards based upon the zoning regulations in place at the time the application was filed. The time of application rule is what is commonly referred to. As I said in my opening, and I guess I'll probably conclude here, the map that was in place at the time this application was filed and processed with the planning board, and it's still in place today, is the 2022 map, which is what we're asking this board to interpret and to confirm what's clear as can be, looking at the map, that this property is located in the NC zone. What we're asking for an interpretation, which is what this board is entitled to do under the law. What they're asking for this board to do is, as I said before, in addition to being, terrifying to any person who practices in land use law, is for you to disregard the zoning map and sort of conclude, based upon a limited presentation, that there's some administrative error along the way. And where does that leave us? This is really only something that a court can do. This board doesn't have the authority, to do that, or, with all due respect, the ability to do that. These are complicated legal questions, And again, you've got your own zoning department or planning department and planning director, who's also done an analysis and concluded that this property's been, zoned NC for 50 years or more, at least 50 years or more. So at this point, I'm probably repeating myself, but.
Okay, thank you, Mr. Tremulak.
Thank you.
Ms. Delvecchio, Mr. Tremulak did add another exhibit, so do you have anything to say with respect to that, A5?
Yes, with respect to A5, so the reason that I didn't go through the 2016 map is for a couple of reasons. I have here a response to an OPA request that my client submitted, which states there are no records of rezoning for 260 Park Street attached to the zoning map from 2006, which I showed you, which was the basis for the new map prepared in 2016, which is also attached, a copy of which I have here. This is the 2016 map. In 2016, there were 2 ordinances that amended your zoning map, neither one of which amended the zoning map for this area or rezoned this in any way.
You do concede the 2016 map puts the subject property in the NC zone?
No, I do not. Because I argue that it was improperly done. The 2 ordinances that were...
What does the map show? Does the 2016 map show the property in the NC zone or in some other zone?
The
map, just the map.
Hold on, I have to zoom in. 1 minute. It's the same argument that I'm making for the 2022 map.
I understand your argument, but
right.
I asked you whether the property is shown as, in the 2022 map, whether it's shown included in the NC zone, and you said yes, but that's an error.
It is an error.
Is that your same position for the 2016 map?
Correct.
Okay.
Because the 2 ordinances that were adopted amending your zoning map did not make reference to this specific property, weren't a cover ordinance. There was nothing that amended it in that fashion.
Okay,
to
thank
put
you.
it properly in there.
All right. I want to say something, and then the board can ask questions or try and bring this to a close. But what you have really in front of you is really a narrow question, and it's a rarely seen procedural move to request an interpretation of the zone map. But we have it in front of us, based on a kind of a tortured history before the planning board, but it's now here. And the question that the applicant is asking is, zoning board, we want an interpretation, is the subject property in the NC zone as per the zoning map? And that's the subject property being 260 Park Street. Now, that current zoning map, everybody agrees, was adopted in 2022 by ordinance 0-22-16. I think I haven't heard anybody present any evidence that says that that map shows the property in any other zone other than the NC zone. There is an allegation that it's erroneous, but if you stare at the map, it's clear as day in the NC zone. It's unambiguous and shows it as such. Now, Ms. Talley's memo that I think Mr. Tremulak marked into evidence, that March 3, 2026 memo, she reviewed the zoning maps. She picked 74, 79, 86, 98, 2006, and 2022, and she concluded the subject property was included in the NC zone since at least 1974. Now, Ms. Delvecchio disputes that based on what she's presented in her exhibits. I submit to you that this whole tortured history of what happened to get us here is not relevant. For our purposes, the sole question is, what does the zone map show the property in? going back and trying to unravel the entire history, whether the ordinances were adopted procedurally, whether they were correctly adopted procedurally or otherwise, whether the maps were erroneous, I think it's outside the scope of the property, of the analysis here. Mr. Trembulac has also raised a number of, I think that's a legal issue, let me just say that, and I think it's clearly one that's for the courts, not us. Mr. Trembulac's invoked all other kinds of legal issues too. His argument that this would be terrifying to the public, not being able to rely on that, sounds like an estoppel argument, also a legal argument. So that's not, and there's case law that these types of legal issues, legal arguments are not properly before the board, they're for courts. Now, where does that leave an applicant? I mean, the applicant really has, the member of the public really has two options as I see it. They can go back to the governing body and they can get them to change the ordinance and/or zone map. I don't think that's going to particularly help them in this case because the application has been filed, there's a time of application rule, and I'm not sure that's going to get them what they want. The other option for an aggrieved party is to go to the Superior Court, where I think this can properly be reviewed under the court rules. You know, we're not bound by the court rules. There's been a presentation. I can't say that it's been an exhaustive presentation. We have a dispute, at least from Janice Talley in our zoning department, who says otherwise. I think if you look at A1 through A3, the property says it's in the NC zone. For our purposes, it's in the NC zone and the interpretation, and we leave the objectors to file in the Superior Court. Any questions?
I'm going to start with Mr. Griffith. Any questions or comments?
No, it's clear to me.
Mr. Church?
I also, it's clear to me also that reliance has to be on something that's visible. The zoning maps as presented was something that the applicant relied on to make his application for before the planning board. I think that that is governing here. Like Mr. Sullivan said, we can't interpret what was in anybody's mind about the zone at the time that the applicant made. He looked at the zoning map and said, that's what I got to do, this is what I have, I can work in this zone because it's available. To sit here and for us to say, gee, you're wrong, it bothers me, because reliability to a citizen of this town is the reliability on the documents presented by the township, by the governing bodies that make these things available. If we can't rely on those things, we have to interpret them all the time, then I think Mr. Sullivan's right. It should go back to somebody, and they, either Superior Court, go to court, or go to the council and say, you got to redo this. For us to sit here and say, gee, too bad, you relied on something that's not true. It is true. It's in black and white. It's on the zoning maps that he relied upon. The township presented as reliable. Therefore, I think that there's nothing else to argue here. It's the public relying on documentation presented by the governing bodies. And that's all we have. We have nothing else, unless we want to litigate and litigate and litigate in your neighborhoods. You can't do it. So I think the reliability issue is he relied on something that was evident, self-evident.
Thank you. Mr. Cruz?
For me, I'm a little bit more confused because I understand the competing interests. On one hand, I think you used the term time of application. You have to use the available information you have at hand. And if the council voted for a zoning map, then that is the information you're using to go with. It's been there for a couple of years. On the other hand, when it comes to both presentations, I was a little bit concerned that neither one of you had, I understand why you didn't do, Mr. Tremblay, because your position is as you've described, but I was kind of confused why nobody bothered to get the filed map. Like typically, in my opinion, ArcGIS-based databases, and I've used them in my personal time, those renderings sometimes have great data. If you go to the NJDEP website, it has all sorts of environmental deed notices, restrictions, wetlands, et cetera, et cetera. Typically, from what I've seen in ArcGIS mapping, it tends to use parcel data or tax data. And if you're trying to determine what true boundary is, you can't rely, you're not allowed, or you can't, in my opinion, you can't rely on tax data to determine boundary. Also with ArcGIS, there's no monument, there's no like datum to tie into. So where I'm struggling is on one hand, I think from a legal perspective, because the council approved it knowingly or unknowingly, that decision is beyond the purview of this court. But in my opinion, the actual line can only be determined if you overlay the zoning map onto a filed map. That's what determines where the lot actually is. So, anyways, that's where I'm at right now. I'm between like the legal and the actual. I don't feel like there was enough information provided as far as where the actual lot line is. However, I have to also take into consideration that the map was legally approved. I don't know typically whether redevelopment, so I've seen redevelopment plans amend zoning, but I'm not aware of when a zoning map is approved, whether it's typical or not, for all the lots that are going to be changed from one zone to another to be mentioned in that approval.
Ms. Harris?
I mean, that's the same question that I have. Would there be any other documentation in which, you know, a lot was rezoned that would be included in the adoption of a new map? Like, do we have all of the information here that shows what happened in 2020?
And remember, I think what we're going here is, this is exactly why we're not equipped to do it, why it's outside our scope. I mean, I think our job is to look at the zone map. I mean, there are instances where, I mean, there's a case back from New Jersey Supreme Court in 1962. It's Loden Inc. v. Hansen, where the zoning map showed a property in a white color. Okay, and the question was that part of a zone? Because there was a residential zone with a white color in it. The zoning board concluded that meant there was not in any zone because of a historical railroad use. But and the court also in that case said that's a legal question. Okay, I think we might be getting a little bit far afield here. I think our job is to look at the map. Okay, A1, A2, A3 show the property unambiguously in the NC zone. I think a court is equipped to go through a historical review, a complete historical review. I'm not convinced that we've seen every zoning map and we've got everything in front of us. But again, that's why I think that's not our job. I think it's a legal question. There are a number of times that legal questions are beyond the scope of the board. Estoppel is one of the issues. There's a case, Spring Steel versus West Orange. You know, our board is also not equipped to comment on the legality of an ordinance. That's Fisher v. Township of Bedminster. We're also not able to opine on constitutional questions, so we're limited. So I'm instructing the board that I think the proper course is to make a motion that pursuant to NJSA 4055D 70B, that this interpretation, the 2022 zoning map, depicts the subject property in the NC zone. That's the motion I'm suggesting.
Understood. I was just kind of asking for my own education, and I think members
No,
of the
you could
public
spend a
asked-
whole lot of time trying to figure that out,
Yeah,
yes.
Yeah, and I think members of the public asked the question, so I was just trying to understand when a
Right.
new ordinance is adopted and there's a new map adopted, would there be anything else that would be available to the public to see, you know, if certain lots were changed?
Besides the ordinance text, I don't believe so.
Okay, thank you.
Okay, so it would be time for someone does someone want to make that motion that I suggested? Yeah, this is an interpretation pursuant to 70B of the municipal land use law. The board finding that the 2022 zoning map depicts the subject property in the NC zone.
I make that motion.
I second.
Can we get a roll call?
Yes. Chair Harris.
Yes.
Mr. Church. Mr. Griffith?
I approve. Yay.
Yes. And Mr. Cruz?
I abstain.
Okay, so that's the interpretation. That carries. There'll be a resolution adopted in 2 weeks, and an aggrieved party can take further action if they deem it necessary.
May I ask a question?
Thank you very much.
Okay, welcome.
May I ask a question now that you voted?
We have 3 other applications that we need to get to. Yes, quickly ask the question. Yeah.
How do you get this fixed? If a person makes a mistake on a map in our town, what I hear you saying is that no one has the power
No,
to address that unless I go to court?
Well, no, you can also go to the township committee. The governing body adopts the zoning ordinances and adopts the zoning map. Okay? You can always make a request for an amendment of those items, yes. All right. What's the next case?
15 Prospect.
Okay.
The next application is application 2972, 31 Marquette Road. Oh, is it not 31 Marquette? Sorry, okay. Do you have the agenda? Apologies, the next application is application 2968, 15 Prospect Terrace.
Okay, this is 2968-15 Prospect Terrace, correct?
Yes.
Okay.
The applicant is seeking a variance from Montclair Code 347-20A to permit impervious coverage of 47% or 35.8% is the permitted maximum. And a variance is also requested from Montclair Code 347-6A to permit a side yard setback variance of 8.1 feet from the southerly property line where a minimum setback of 10 feet is required.
Okay, would you both raise your right hands? Do you swear to tell the truth in the matter pending before the board?
Yes.
State your names and addresses, please.
Alex Fuchs, 15 Prospect Terrace.
And you are the applicant, correct?
I am.
My name's Jeff Hostler. I work for CLC Landscape Design. We're out of Ringwood, New Jersey.
Okay.
And Zainab, are the taxes paid and the notice in order?
Yes, they are.
Okay, you can proceed.
Good evening, members of the board. My name is Alex Fuchs. I, with my wife, Kiersten Fletcher, own the property at 15 Prospect Terrace. We live there with our 3 children and my mother-in-law.
I'm sorry.
Is
your microphone on? You can just press the button.
It's green.
Okay.
Can anybody hear?
Just a tiny
Little
bit
bit?
closer.
Thanks. So as I was saying, we live at the property with our 3 children. My mother-in-law also lives there in the carriage house on the property. We're seeking a variance today to put in a moderately sized pool and patio on the property, as well as a variance to allow a hot tub spa to be a little bit closer to the property line than currently allowed. I believe the variance we're looking for is to allow impervious coverage of 47% on the property. Currently, I believe as we stand, we're at 42% impervious coverage in the property, so I believe we're already over the 35.8% allowed. The property is kind of an irregular shape. We have a carriage house in the back of the property that has the original horse stalls from when it was built in the late 1800s or early 1900s, but it requires our driveway to run from the very back of the property all the way to the street. I wish it was shorter, certainly when it snows. It's the bane of my existence. But unfortunately, because of that and the size of the house and the carriage house, we're already over the impervious coverage limitations for the town. We would like to put in a small pool, as I said, for our children to enjoy, and a patio space that we can entertain at and enjoy with our family. And that's why we're seeking this variance.
So it's a 14 by 28-foot pool plus the spa, is that right?
Yes.
Is there anything you'd like to add?
I would just say, the pool that they've chosen is on the rather small size for what we typically put in, 20 by 40 or 18 by 36. So as we've gone through the process, they certainly had some thought to where they could put this, the size of it, and try to preserve some wall space for the house is historical, garage, carriage house is historical, and you have this long driveway. So when you add those three up right at the beginning, before you add anything that you typically see in the backyard, you're already over the house. And that kind of gives the option, you don't want to take down a historic house, you don't want to take down a historic garage, and we need the driveway to get to the garage. So there's a couple of anchor points that we have already, as we start the design process, things we can't really move or do stuff with. So we did the best we could with the space available, and of course that puts us in front of you guys today.
Okay, we'll start with Mr. Cruz. Do you have any questions?
How much disturbance are you creating?
Disturbance, 8,000 square feet. Room around the house, and then the culvert chambers in the back are drainage off the driveway, creates kind of a big circle there. Big area.
And were there any other design considerations made to try to get the pool further away from the setback?
The pool is not an issue for the setback. That is within the appropriate setback. If it's a hot tub, that was a little close. That's it. 1 feet versus the 10 that we need. And if you're looking at it, drew something up that had that closer to the corner of the house, but it just kind of created a pinch point. You have kids going back and forth from the pool to the dining area. Here's, we're, I think from the hot tub steps, it's like 6 feet. If we moved it into, it would be like 4 feet. And that's just too tight of a path. Kids going back and forth. Didn't want them to bump into each other, didn't want them to trip over the steps for the hot tub. So we drew it that way once, and I said, no, that's just pinches it in too much.
I have no further questions.
Mr. Griffith?
So you're saying that the pool is 10 feet away from the
Yes.
property line? And you're saying the hot tub is 8 foot?
Correct, 8.1 feet. The pool is actually.
And that is the only,
The pool is actually 11.1 feet from the side, 11.2 feet from the rear.
I saw the 11, but it's the side yard that we're concerned with, right? That's the only,
The pool is 11.1.
on the back it's 11.1, and on the side you're saying it's 11.1?
Yes.
And the hot tub is 8 foot because,
Because of the corner of the house that's there. the house goes around, there's this enclosed porch on the side there, and that's where we didn't want to squeeze it in too much.
I don't know, I honestly don't see the difficulty with complying with the 10-foot, personally. I don't have any other questions.
Just from the photos that you sent, is the pool going in the area where there's a bunch of Adirondack chairs? Is that?
Yes, that's correct.
Okay. And are you planning any shrubbery or any fencing around the pool and the spa at the property line?
Yes, I think there's plans for large shrubs along the property line with, I believe that's 17 Prospect Terrace.
Yeah, there's 13 green giant arborvitaes. We're going to plant 8 skip florals, which are perfect for screening the property.
Okay.
The screening, the ones that privacy ones are the giant green arborvitaes and the skip florals.
Okay, and so are those going along the rear and the side property line, or just the side?
I think it's both. Not the rear, I think that's pretty full, right?
Yeah, the rear near the pool is quite full. It would be on the side against the closest property line.
Okay.
And with respect to your question about the fence, there's a pre-existing 6-foot tall fence along the property line, and we're going to close that in with additional fencing on the driveway side and on the side of the house, that the entire backyard is completely enclosed.
Okay. And in terms of the spa, I understand that the stair is kind of like the limiting factor here. Is there any way to relocate the stairs so that you could comply with the side yard setback?
And again, you get close to that corner. We just don't like the tightness of it. And I know.
Oh, yeah,
We
we have spoken to our neighbors on that side of the property, and they don't have any problem with the spa being that close. They've only asked that we put in a ladder so that they can come over to our side and use it.
Be careful.
They have their own pool, but they don't have a hot tub, so I think that's the draw there for them.
Okay. Any members of the public with comments or questions for this applicant? Please come up.
Okay, would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
Yes.
State your name and address.
I'm Courtney Conway, 79 South Fullerton. We're backdoor neighbors.
Okay, and this is an opportunity to either ask questions or comment or both.
Thank you. I have 3 questions. One that I already raised and I know you looked into. Our sewer line runs back to Prospect. So we sent a map over, and I think you've examined whether or not there's any issue with where the pool is going. And so I just wanted to confirm, is that all okay?
So we've got a 1923 sketch of where the sewer line goes. Obviously, we're not going to disrupt that. Our plan is to get one of the companies that can mark that out and actually put the flags in the ground and find the depths to find out exactly where that is in relation to the to where the pool's going. If you look at the map that was given, like the back doesn't really angle in like you see on this site plan. So we know it goes that way, we're just not 100% sure. So that was our plan to address that. And our thought was, if it ran down that end of the pool, we would switch the deep end of the pool and the patio that you see there, so that the patio would be on the neighbor's side, because we could put that over a sewer pipe, where we can't put a deep end of a pool over a sewer pipe because we dig into it. So our thought was, if it's in the way, that would be just flip the pool and the patio around on that upper portion there.
So what you're saying is that you're agreeing to mark the sewer line, and that you will not, if the event this application is approved, you will not interfere with that sewer line, and that would be reviewed and approved by the township engineer. Is that fair?
Yes. I mean, if there was an option to relocate it, we would consider that obviously the home, 15 Prospect's expense. So we're just trying to keep our options open in that, but yes, it's something we wanted to get through this, and then we'll figure out sort of the details, but that was our game plan.
Thank you. I'm sorry about the sewer line. Then my other question was where you have like there, I don't know if it's an electrical wire, but there's a wire across the backyard. Is there any need to move that now that you have the pool, or was there any plan for that? I couldn't see it on the map, so I just was curious.
It's on the site plan,
Oh,
and it's
okay.
not over the pool.
Okay. I was curious because I didn't, I was not wanting it to come toward me, so I just wanted to
Typical
check.
problem in
Okay.
Montclair, a lot of the power lines run through the back.
Okay. Okay. I thought
And
that
that
was my-
sewer line, that's for the benefit of your property, correct?
Yeah, I think that.
And what's your address again, please?
79 South Fullerton. I think the people who built our house bought the backyard basically from the people who built their house. And I was told when we bought the house that the gravity would take, like that we would have, if we had the sewer line go to 79th Street, to South Fullerton, that it would have had to been pumped uphill, but because I was told it flows down that way, and so that's why they did it. But I don't really know.
I kind of got the impression it was one big lot at one point.
Yeah.
That was based on the drawing I saw.
Yeah.
Yeah, I mean, it happens. It's just, we want to make sure that your sewer line is not getting interfered with. And that's really going to be, if the application's approved, up to the township engineer to figure that out.
Okay.
Absolutely fine with making that a condition for approval. Yeah, absolutely.
Okay. Thank you so much.
Thank you. Any other members of the public? Okay. Members of the board, we can comment.
I'm generally in favor with the conditions as mentioned before, that the sewer line remains unobstructed and all stormwater management requirements are met for a minor development. Yeah.
Mr. Church?
Yeah, I'm in favor of it.
Mr. Griffith?
I'm in favor of the impervious coverage. That's fine, as long as you address it by stormwater management, which I believe you're doing. But I'm not in favor of approving the exception to the side yard setback. I think there's plenty of room in the backyard to locate that hot tub within the standard required setback. It's 2 feet. The wooden deck back there, there's from the house itself, there's, I don't know, a good amount of distance. So I am not in favor of approval of that part of what's being submitted.
Mr. Griffith, if I might, it may be a little deceptive on that plan. That's a fully enclosed porch. It's not a wooden deck.
It's an enclosed porch, you're saying?
It is.
Yeah. I still think you can make the 2 feet work. I don't see that as a hardship, enough of a hardship to change to grant this exception myself.
Yeah, I'm in favor of the impervious coverage variance. You're already at 42%, and you're adding a minimal amount with these improvements. I do think with some moving around of the stairs for the spa, you could meet the side yard setback relatively easy and still not interfere with the flow between the porch and the spa. So I would agree with Mr. Griffith. I don't think that there's enough of a hardship to grant the side yard setback variance. So would someone like to make a motion?
So any motion to approve should be subject to the applicant installing stormwater management measures to address impervious coverage in excess of the ordinance maximum to the satisfaction of the township engineer. The applicant's bound by all representations made on his behalf during the course of the public hearing. The applicant's responsible for all inspection fees incurred under Montclair Code Section 202-27, as well as escrow fees incurred in connection with review of this matter. And the applicant has stipulated they would mark the sewer line and not interfere with that sewer line, which is for the benefit of the property owners at 79 South Fullerton, and that would be subject to review and approval by the township engineer.
Yes.
So if someone
I
needs
so
to make a
move.
motion one way or another.
I so move as Mr. Sullivan stipulated to approve.
Okay, so is that to approve both variances, just the impervious coverage variance? or
To
what?
improve, yes, to the, I move to approve the lot coverage variance, to deny the side yard variance, and to condition the approval as determined by Mr. Sullivan for stormwater management, sewer marker.
Subject to all those other
Subject to Mr. Sullivan's other conditions. I so
So
move.
is there a second?
I second.
Okay, so the motion is to approve the impervious coverage variance, but to deny the side yard setback variance. It would be subject to those conditions that I articulated, so we need a roll call.
Chair Harris.
Yes.
Mr. Church.
Yes.
Mr. Cruz.
Yes.
Mr. Griffith.
Yes.
All right.
Thank you.
Thank you.
Okay, the next application is application 2972, 31 Marquette Road.
Which one is this one?
Good evening again, Alan Tremulac.
You're back, huh?
I'm back. I have a trifecta tonight. I'm appearing on this application on behalf of the owner of 31 Marquette Road, Defne Gulbuken. This is a really simple, straightforward application. The client is expanding a single-family house on a narrow lot on Marquette, where the only room for expansion is to the rear. And the only variance that's triggered by this is a rear yard setback variance. And I have one witness to present this evening, which is Sardar Kamen, project architect, and I would ask that he be sworn.
Would you,
Yes, they are.
all right, would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
Yes.
State your name and business address.
Sardar Kayman, S-E-R-D-A-R, Kayman, K-A-Y-M-A-N, 2160 North Central Road, Fort Lee, New Jersey.
Sardar, what is your occupation?
I'm licensed architect in many states, including New Jersey. I have both bachelor's and master's degree from NJIT
Okay.
in architecture.
Okay, how long have you been licensed in the state of New Jersey?
It's about 10 years.
Is your license current and in good standing?
Yes.
Okay. I think you testified on at least one application that I'm familiar with before this board a number of years ago, 133 Forest Street,
Correct.
right? And you testified, you qualified as an architect in that application?
Correct.
Okay. You offer him as an expert in architecture? Thank you. All right, Sardar, why don't you explain to the board the project that you've developed, designed, I should say, for 31 Marquette Road?
So if you refer to the A001 sheet, it's an unusual shaped lot, 53 feet wide and 125 feet deep in one side and 100 feet in the other side. Then there's a little notch in the back, so that makes it unusual shape. It's not a rectangle site. So this is a single family house, and the Marquette Road is in the front, and in the back there is a small river, and we are proposing to make an addition which is 10 foot 10 inches by 27 feet. Some portion of the Addition is within the required rear yard setback, which is 25 feet. So in the plan, it shows 20 feet 4 inches, so it's about almost 4 feet 8 inches short.
Yeah.
So in the interior, if
Can
you
you talk a little bit about, what it is you're looking to accomplish with the expansion?
So
of the house?
we are looking to add, relocate the kitchen and enlarge the family room and living room. And also in the second floor, the kids' bedrooms, 2 kid bedrooms, we would like to add a closet and 1 additional bathroom. And in the attic, we are adding 2 dormers so that can be used as a playroom. The basement of the house doesn't have enough clearance, so the kids cannot play in the basement, so they are looking to put some playroom in the attic as well.
Okay. And you pointed out the variance, and it's, you've got the, I guess, the survey of the property with the site plan there, and, I think it speaks for itself. I mean, the reason for the variance has to do with the unusual rear lot line, correct? Yeah, because you comply with the setback, on the northerly side, on the, left-hand side looking at the page, but then as the line moves in, closer to the house, you're unable to meet the requirement.
Yes, that's correct.
And by the way, what is to the rear of this property?
It's a river.
The third river?
Third river, and then also there is some public land in the back.
I think it's the Alonzo Ponzel Preserve is to the rear, I believe, but there's no houses
No houses
to
in
the rear that would be
Correct.
impacted by
Correct.
this setback. Is that correct?
Correct. And I would like to just, if you refer to
Oh, yeah.
203, we have renderings showing the
You might want to.
existing.
Maybe,
It's-
oh, or you can do it on that. Yeah, there you go.
I think so if you look at the lower left corner, that's the existing front rear. So we are replacing the siding, windows, and shutters, enlarging the windows, and adding a small canopy above the garage door. And if you look at the lower right-hand corner, that's the existing rear view. That's it's an L shape with the small deck in the back. So that will be removed, and we will be just squaring off the building. And the glass area that you see on the left, that will be the living room and dining room, and on the right will be kitchen that you can walk out to the rear deck.
I think that's all I have.
Okay, Mr. Church, do you have any questions? Mr. Cruz?
Mr. Tremblay, I take it that with the third river, that's a proper water course, right?
Yeah.
So as part of the condition of approval, any like DEP related?
Oh, sure. Yeah.
Okay. No further questions.
Thank you. Mr. Griffith?
There's a fence there as well?
Correct. There's
What
an
kind of
existing
fence?
fence in the back.
In the back, it's a fence on the, I don't know what I'll call public property, because I don't know what else to call it. But it's not private property, correct?
Correct.
Yeah. All right, I don't have any other questions.
I'm just curious, do we know why that rear property line is notched like that?
I looked at the tax map and, the survey. This is the only lot that has that notch. I don't know the reason.
Okay.
The other lots are straight line, looks like. And in the zoning tax map, actually it shows more straight than the real survey comes,
With the notch.
that's how we see that notch. Yeah, I see.
It's interesting, I hate to bring this up, but the zoning map seems to be different. But we're not.
Oh, you're laughing now.
We're not able to rely on the zoning map for purposes of this application. I think, I don't mean to interrupt if the board has additional questions, but.
Well, no, I was just
Sure.
curious. No, I think this is pretty straightforward. This is a very odd-shaped lot, and you are encroaching minimally on the rear property line. So I would be in favor of this application. Mr. Church?
I'm sorry, did we open it up to the public?
Oh, I'm sorry.
Yeah.
Um,
That would
do
be,
you-
if there's any member of the public who has a question or wants to make a statement with regard to this application, now is the time.
Okay. Mr. Griffiths? Sorry. Okay. Mr. Church?
No, I have no.
Mr. Bruce?
Yeah, so just my one comment about the DEP thing. If memory serves me correctly, I believe you're not allowed to disturb 25 feet from top of bank along the Third River. And so I'm trying to think about... So just basically just that as you're going through the process, if you find out that you can't develop within that space because of DEP regulation, that you may need to adjust the design. And I'm not sure if you would have to come back here, or if that's something that would occur, that you would deal with the building department or the engineering department. But I am generally in favor of it.
Okay, would someone like to make a motion?
I make a motion to approve the variance requested for the setback at 20.
That would be subject to our
0.33.
standard
Yeah,
conditions.
not the stormwater management. I think we've only been imposing that for improvement
Yeah.
coverage variance. So again, it would be applicants bound by all representations made at the hearing and subject to paying inspection fees and escrow fees.
Second.
All in favor?
Aye.
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 Thank you very much.
Thank you. Have a good night. The next application is application 2953, 105 Upper Mountain Avenue.
Good evening once again. Alan Trembulak, appearing for the third and last time this evening. Appearing at this time on behalf of Yaakoub Hijazi, the owner of 105 Upper Mountain Avenue. This is three variances related to a substantial, what's become a very substantial renovation project on this property on the east side of Upper Mountain Avenue. I'm going to present some of the history of the site that's brought us to this application, but there are three variances that we're requesting. One is for a new garage which was mislocated and improperly installed by a prior contractor who's no longer working on this project for that and other reasons, where the garage was positioned 8 feet from the side yard with an 8-foot side yard, whereas the ordinance requires 12 feet. Second variance is a de minimis application for a height variance for that garage, which is about 3.5 inches higher than the 15-foot height limitation for accessory structures. And then the third variance is for impervious coverage. We're exceeding the maximum permitted is 35%. We're exceeding that and requesting a variance to permit 44%. And as you'll hear, there are substantial stormwater improvements that have already been installed on this property to more than mitigate the additional drainage resulting from the impervious. So, is Ryan?
Yeah, I don't know where he went.
There it is. Okay.
Before you get started in the formula.
All right, so.
Please go ahead.
Taxes are paid and notices in order.
Thank you.
Thanks.
No, but just one person. Just one.
Okay. Would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
Yes.
State your name and address.
Ryan Hart, 2 Yaakoub Place, Montclair, New Jersey, 07042.
I understand coincidentally that I think you were before this board recently for one of your own application involving one of the
Yes.
property that you own.
Yes, 12 Montclair Avenue, and
Okay.
we were successful.
So, on this application, you're appearing in your business capacity, and would just identify, what's your business affiliation?
I purchased Jack Finn and Company, Building Contractors LLC from Jack Finn 3 years ago.
So you're the owner now of Jack Finn?
Yes.
And, you know, construction company in Montclair,
Yes.
long-time construction company. Okay. When did you, when I say you, I'm talking about, Jack Finn and Company, first become involved with this project at 105 Upper Mountain Avenue?
May 2025.
So about a year ago?
Can you, I'm having trouble hearing you. Anybody else? I'm just hoping it's not me.
Sorry.
Can you just make sure the microphone's on? Okay.
May 2025?
About a year ago, correct? All right, and this project was in progress at the time you were hired, correct?
Yes, it had been going for a few years, or a couple of years at least.
Okay, and you were hired by the property owner?
That's correct, Mr.
And did-
Hijazi.
Okay, and did you replace a prior contractor who had been working on the project?
I did.
Okay. Just talk a little bit about the project itself, what had been done at the time you got involved, what's taken place since then, and it seems to have been an evolving project, as I understand. So
That-
just explain to the board the history as you know it.
Okay, sure. So Mr. Hijazi is a business owner, and he owns a significant amount of commercial property in Paterson, New Jersey. And this is his first major residential project, and he attempted to use his commercial contractors to renovate this house in Montclair. And I would describe them as like unqualified for the task, and not paying the amount of attention that is necessary to build successfully in Montclair for high-end residential construction. And so the project had been going for a couple of years as they uncovered things that were, this house had been, for lack of a better word, neglected for a long time by the previous owner. So as they uncovered things that were in poor condition, they were just ripping things out without really doing taking the correct steps. And that's, they went as far as they could, I think, before the property owner lost his patience with them. And they did enough that the garage was constructed, it was finished. That was the only new building on the lot. So that was the simplest construction, I would say, for the previous builder. The interior of the main house, the main structure, was what they thought was complete. And it had passed rough inspections, but we took a look at it and we were like, there's no way, these are not safe conditions, like this is not right. There's so much about this that's not right, not just as far as like the design, but as far as like the safety of the potential occupants. So when we took over our initial focus was on making the property safe, putting up guardrails and things like that, and from there we moved into correcting the many mistakes, and that has taken us about a year to get it back to a place where we feel like we could finish the house and have it be, what it should be.
I understand there were some problems initially, I guess, with the exterior of the house?
Yes. So the exterior of the house, it's a beautiful, beautiful house. It was designed as a replica of a house in Italy. It's a stucco facade house. The homeowner is very committed to restoring it to its original glory, and that's been his drive since the beginning. He just didn't have the right people to execute it. So as they got into the renovations, they noticed that the stucco was failing and that the sheathing behind the stucco was failing. So they ended up just like kind of tearing it all off, which they shouldn't have done without going through the proper channels. But ultimately, it got put back together as a replica based on historical photos. And so it is a beautiful representation of what was originally designed. And aside from building the garage in the wrong location, everything else was kind of salvageable with a substantial amount of rework. And that's kind of where we are.
That's what you've been doing for the last year?
Yes.
And it's ongoing?
It is ongoing, yeah. So it began with, making the property safe, reconstructing the drainage. The drainage on the property was very substantial because of the amount of disturbance. Like this was before us, but whatever it was, the scope of the project made it qualify as something that required more than what is typical to me as far as like stormwater management for additions of this size. So it became a property where the stormwater management system had to meet requirements that are much, much higher than what is typical for additions, alterations, even new construction in Montclair, because of the amount of soil disturbance. So the system was designed to meet those requirements, but the previous contractor installed the system completely incorrectly. Like the tanks, which are substantial, they're 9-foot diameter, I believe, by something like 10-foot tall tanks, 6-foot tall tanks. 6 foot wide by 8 foot tall tanks. They were supposed to
Mr.
be.
Hart, if you don't know the answer, then don't testify. We can always bring up somebody else.
We're going to have another expert actually who's going to talk about stormwater.
Okay, sorry. So I was
Okay.
just trying to give context to
Sure.
the things that were done incorrectly. So it all had to be removed and reinstalled in the proper locations per the township engineer's guidelines, and those things, along with the other things that needed to be done on the property, that's what we were working on for the last year.
Okay. Now, with respect to the garage, I think you indicated that the garage had been erected before you came on this job a year ago.
That's correct.
Do you have any explanation or understanding as to why the garage was located where it's located, only 8 feet off the property line, whereas the requirement is 12 feet?
I think it was a mistake.
Just another mistake by the same contractor who you replaced?
Yes.
Okay.
Yeah.
Okay.
There's plenty of property there. Like there was no good reason to do it other than they probably didn't bring a professional surveyor out to plot the corners of the building and put it in the right place.
And the garage also exceeds the height requirement by a few inches. Is that correct?
That's correct. There they didn't make a mistake in the same way. The roof itself is a clay. It's a terracotta roof. And they put these finials on the top of the roof that are like 10 inches tall and kind of look ridiculous. That's what made it exceed the height. So we have been searching for finials, which are like kind of end caps on the hip of the roof that are shorter, that match the rest of the roof, so that it
What
will.
you're saying is that you could correct that if the board was not willing to grant the variance to allow.
That's correct.
Yes.
Yes.
3.5 inches or so. Okay.
Yeah.
Okay, I think that's really all I have for Mr. Hart. 'Cause again, we have an engineer who's going to testify regarding the stormwater
Okay.
management. Don't
Thank
go
you.
away.
Oh.
You're not done.
Mr. Church, do you have any questions for this witness? Mr. Cruz?
I have no questions.
Mr. Griffith?
Are these questions limited to just the impervious coverage, or can I talk about the lot line
They're
issue?
limited to his testimony.
Okay, I have no question.
I guess I'm trying to understand the history of this project and where you came in. How much of what we see on that plan was work that you completed, and how much of it was work that the previous contractor completed?
The pool is yet to be constructed. That's part of the impervious variance that is requested here. We didn't obviously progress with the pool construction until we got approval to do so. The garage and the main house structure was existing, with the exception of an addition to the rear of the kitchen, which is in the northeast corner of the image we're looking at. So that was also constructed. So
No, you can't.
yeah, sorry. So I'm sorry. To answer your question, as far as this this image is concerned, this was all constructed with the exception of the pool.
Okay. And so the variances in regards to the side yard setback and the height of the accessory dwelling, that's an existing condition that you're trying to quote-unquote make legal now?
Yes.
And then requesting the impervious coverage variance for the pool and the pool deck?
Correct.
Okay. All right. I think I understand. Thank you.
Okay.
Any members of the public have any questions or comments for this witness? No? Mr. Tremulek, can you bring
Okay.
it?
Bruce Rigg?
Good. Thank you.
Hang on.
Would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
I do.
State your name and business address.
My name is Bruce Rigg. My office is at 1000 Maple Ave, Glen Rock, New Jersey. I'm a licensed professional engineer and land surveyor in the state of New Jersey.
How long have you been licensed as a professional engineer?
44 years. I'm licensed in 1982, also a certified municipal engineer. I've testified between over 90 municipalities. However, I don't think I've been before this board. My plans have been here, but I don't think I have personally, so.
Offering him as a professional
We
engineer.
accept him as a witness. Thank you.
All right, Bruce, the board has your site plan, I guess, and the grading and utilities plan, and I'd like you to discuss the grading and utilities plan, the stormwater management that's proposed for
Sure.
this property, and in the course of doing that, you can talk about the impervious coverage.
Well, try and clear up some of this. We've been actively participating in this application for approximately 3 years. I've been fortunate or unfortunate to see many different contractors go through until we have current contractors who've been fixing the errors of what's happened in the past. The plan that we have in front of you now is the site layout plan of property 105 Upper Mountain Avenue, originally dated September 2023. Last revision was February 25th, 2026. We worked with I believe it was 2 contractors ago, who we found out by chance that they constructed the garage, and unfortunately didn't call us first, so they positioned the garage too close to the property line. Their comment was it's because of the jog behind it in the rear line, it goes over 4 feet. They assumed that 4 foot continued. So that was their reasoning, but it's still at an 8 foot setback instead of the 12 foot that's required. The height of the garage, as was previously stated, it's slightly above. Construction materials may have something to do with why it's a few inches higher than it should be. The plan you see in front of you now, this is, as you can see, I believe there's something like 16 or more revisions. This is the final layout of the property that our client would like to have, with the everything as it's shown on here. Most of this is in place with the exception of the swimming pool area. We have listed on the plan the only variances we are requiring are the maximum height on the accessory structure at 15.3, side yard of 8 feet for the garage versus 12 feet required, and at 44.1% impervious coverage where 35 is permitted. I'm not sure what to say about this other than this application is made it through many different modifications in the field and on our plans, all with our client's intent to try and make this something special to himself and I guess to Montclair. We're showing the walkways as he's proposing. Most of the building construction is in place. I don't believe the driveways are finished. I think they're also waiting for final results. The retention system, as proposed, when we started this application, we were hired to give a plot plan for a garage, and it's sort of expanded beyond that, and that's where, once we went past a half acre of disturbed area, Montclair's ordinance is specific. While most municipalities in the state standard has 1 acre of disturbance, Montclair has 1/2 acre of disturbance, creates a major stormwater project versus a normal or a non-standard, non-major stormwater project. It changes the entire criteria for what you have to collect stormwater for. Instead of reducing the runoff and maintaining the 0 increase in runoff, you now have to reduce the runoff for the 2, 10, 25, 50, and 100-year storm lower than what it was before any of the work started, which is where the system kept growing to meet this criteria. We haven't finished the Neglia has provided us with a review of the application. The last time we talked was the end of last year, and I stated to them respectfully that we would gladly try and finalize the retention and all the rest of the drainage, but we figured we should have this board's input before we go back to them with the final product of what was going to be built. It's essentially the application.
Can you talk about the stormwater, your design for handling the stormwater and meeting the Montclair requirements for a major development? Because I think it's pretty substantial from what I've seen.
The unique part of this property, which is pretty much everyone
Can you speak into the microphone? Yeah, thank you.
The unique part of this property, which all of them on this side of Upper Mountain Avenue, the sloping down towards the rear, so any water on our site plus water from both of the adjoining properties go directly onto the adjoining property. We have a 5-foot strip that goes down to the next street, which we really couldn't collect the stormwater and take it down there. Actually, our sewer connection comes through there, and I believe the electric connection comes up through there at this present time. So what's happened is all of the stormwater for all the impervious on site now has to be collected and retained on site so it doesn't affect the adjoining neighbor. Where normally you would be required to maintain the existing runoff and not exceed it, we're now in a position where we're trying to collect all of it. And that's why the system ended up growing to the size it is at this location.
Can you talk about the size of the system and the number
Well,
of seepage pits? et
Well,
cetera?
you've got 12 seepage pits. The entire area around the seepage pits, that's all gravel, down to the depth a couple of feet below these pits, so it's about a 10-foot deep stone bed, essentially the size of the backyard. Anything that's not being proposed with improvements is a retention system at this point. Part of the issue is not even the stormwater we can collect with no issue. There's another part of the stormwater which becomes rather intense, but it's called mounding, where they now have us design, when the water goes into the ground, it mounds up, and we have to show how far that mound goes onto adjoining properties. The mounding is more of a problem than the stormwater. We've collected the water, but if it gets too high, it goes onto the neighboring property, and we're not allowed to do that. So the system grows bigger just to try and keep the mounding down to a lower level. All part of the major stormwater, which is not part of a standard, or what we would call a standard stormwater management plan for a residence.
So does this plan that you just described and shown on your grading and utilities plan, does this comply with the requirements for a major development on the Montclair Road?
It does. We haven't submitted the final results, as I said, until we heard from this board. We wanted to make sure your input, what's approved, what we're proposing. If it's granted, we'll include that in our stormwater calculations that go back to the borough engineer.
And I understand you've had some interaction with the town engineer. And has he more or less conceptually approved this plan with the 12 pits?
He's asking for, most of it is finite criteria that we have to satisfy to go along with it. We believe the size is a sufficient size. He's asking for us, most of these pipes were installed possibly by the original contractor. He's asking for us to get sizes in pipes, so we have to go out and actually expose up each one of these to come up with the information that's already been installed by someone else. That's the type thing we have to finish up, but we intend to do that.
And you certainly understand that ultimately you've got to satisfy the town engineer.
Yes.
Okay, and you intend to do that, correct?
Yes.
Okay. In your opinion, does this plan that you've designed meet the, subject to the town engineer's approval, does this meet the requirements for a major development?
Yes.
Okay. And is it your opinion also that this system as designed with the 12 seepage pits, et cetera, is adequate to mitigate the additional runoff resulting from the additional pervious coverage exceeding the 35%?
Yes.
Okay. Thank you. No further questions.
Mr. Cruz, do you have any questions for this witness? Do you have any questions for this witness?
Yes, a couple. So the selection of dry wells or seepage pits, those were already installed previously by the contractor who...
Our original design was for a 6-pit system, and the contractor took it on his own to add some additional pits. The system sort of grew as it was going along also. But it's the pits, there are various ways to do this, whether it's with pipe or pits. Since we've had the pits in the ground, we've continued with that.
And the time when this whole process started was, you said, I believe 3 years ago?
That's when we began work on the project, yes.
So as far as the quantity reductions go, you are meeting the future 100-year storm
Yes.
reduction?
Yes.
Okay. I have no further questions.
Mr. Griffith?
So, I'm not interested in the history, I'm interested in the end result. At the end of the day, you have a stormwater retention system that far exceeds the requirements of the additional impervious paving that you have, or surfaces that you have, is that right?
It will address the requirements. It's not far exceeding. It will meet all the requirements
It
of
will
the...
meet the requirements, but it doesn't exceed in any
The
significant way.
it may exceed, but it's not by intent. It's the system was designed to meet Montclair and the state of New Jersey stormwater management regulations.
Okay. I was hoping for more, but that's all right. It is what it is. Thank you.
What we've done is, if it helps, is this is collecting all the stormwater except for the lawn area in the back. Everything else is on the site is being collected and put into the system. So anything from the wall by the swimming pool, below that, which is grass, that's the only stormwater that actually goes towards another property. All the other impervious, everything is collected, everything on the site has been collected in the system. So it's far less than what the neighbor sees today. We'll see far less than that when this project is finished.
So you've reduced the amount of water that runs off from your site to the neighbors?
Yes.
In a significant way, which all you would be required to do is to not put more water onto your neighbor, correct?
No, actually, once you hit the half acre of disturbance, the new regulations go into effect. Most residences, you don't have the half acre of disturbance, so you don't go through this system. Once you hit the half acre of disturbance, you now have to go through this criteria.
Okay.
That's why we're where we are.
All right, I didn't understand that. Thank you.
No questions, Mr. Church? Yeah, okay. Just really quickly, are you aware of any issues with stormwater reaching the adjacent tenant behind this property lot before these improvements?
I believe at one time there was an issue, but I think the contractor has addressed that, so I believe the neighbor has a better situation already. And it's not water from our site, I think it's water from an adjoining site, which was also running onto the neighboring property, which has been addressed also.
Okay, so with these improvements, are we saying that there will be no water?
There will be, well, I can't say there will be none, but we've collected all of the stormwater except for this last section in here, and it will be far less than what's going towards the neighbor before we started the project.
Okay. There were two suggestions from the HPC. I'm not sure if you're the correct witness to address them. Number one, the commission recommends that the applicant reduce or reassess the width of the front driveway to ensure that it's properly scaled to the property. Is that something that you've reviewed?
I saw the review, so I understand these paver perimeter, that is all installed. It would mean tearing up all the Belgian block and doing it over again. Can be done. It's something that my client would prefer to have the driveway as it is without having to disturb what has been installed already.
Okay. And then the second recommendation was that the location and configuration of the retaining wall adjacent to the garage be further reviewed to ensure the proper alignment with the property boundaries.
Again, that wall is intact. It's online in the back corner, and it's 2 foot clear in the front corner. We would prefer to just keep it as is. It's an area that's, we would lose the 2 feet by the garage, but it doesn't affect the neighbors. I think there's landscaping in that area also.
Is any of that wall visible from any adjoining property? Or from the street?
From the street, no. from the adjoining property to the north, I believe it is, he might be able to see some of the wall, but he'd be looking down on it because their house is up next to ours.
Is there a way to get in between, you said there's landscaping on the neighbor side, is there a way to get in between that wall?
We showed some of the landscaping going down. What happens here is because it's such a small distance and the existing fence is actually, instead of following the property line, it runs straight over to the bend. So there's sort of a no man's land in there now that we could just relocate the fence to go to the edge of that wall. And
Okay. Yeah, we just want to make sure that you can maintain that area, you
Yeah.
know, if anything gets back there, yeah.
It's not an issue. While it is 2 feet, he should be able to maintain that with no issue at all.
I just had one more question. So you had mentioned groundwater mounding. What has soil testing been conducted on the site?
That's been part of our issue, is to properly test groundwater mounding, our test holes had to go down about 20 feet, and
Yeah.
we've done all those tests. We've gone through all the excavations, everything's been done to get this approved.
So there was no, in terms of like a water table or like clay, silty?
We have all the information that the engineer needs. You look for the most restrictive zone is how you design the mounding. So if you find modeling at 17 feet, you actually design it over 17 feet down. That's what we look for. And it's all part of the design.
Okay, all right, thank you.
Does any member of the public have any questions or comments for this witness? Please come up.
Okay, so this is limited to questions of this witness. After all the testimony is presented, then you can make comments. So give us your name and address, please.
My name is Seth Yellen. I live at 118 North Mountain Avenue, the adjacent property.
I'm sorry, North Mountain?
North Mountain,
Below.
below,
You said
correct.
adjacent, okay.
On the eastern adjacency.
Understood.
So I guess the question I do have is the stormwater management plan, has that been approved by the town engineer?
It has not been formally approved yet.
And the seepage pits that you've put in, do they extend the full length of the eastern boundary of the property adjacent to my property? Or do they terminate prior to where the pool is?
They're shown on the plan here, this location.
So in that southern section at that end, has there been a stormwater management plan to address directly? There's a natural gully in that area that directs water eastward into my property. Is there a plan there that manages the stormwater runoff that is not captured in those retention pits?
I believe it's at these, I'm not sure where exactly you're talking about, but if it's...
Right there, where you're
right
pointing.
in that corner. where I'm
In that
pointing.
corner.
Yeah. That's the water that's coming from the neighboring property. I understand of the issue, and I very honestly, I thought it was addressed already by the contractor.
And in that section is also the area where you're looking for the variance of impervious coverage?
Well, the pool is in this area, but the pool meets the setback requirements.
But I'm talking about the impervious coverage variance. That is the area.
Impervious coverage, yes.
And that's also the area where the seepage pits do not cover runoff
Well,
from
no,
that area.
The stormwater from the pool and the patio will be collected and put into the stormwater system. So that area will be also addressed. This area where the retention system is the only lawn area that's going to remain that will be graded towards.
Right, because that all previously was lawn, right?
Yes.
Right. And those seepage pits were put in by the current contractor or by the prior contractor?
I believe they were reinstalled by the current contractor.
So they removed them and then they replaced them, or they just modified them?
Yeah, I modified their locations.
Okay.
Mr. Tremulak, your next witness, please.
Yes, next and final witness, William Stimmel.
Would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
I do.
State your name and business address.
I do. My name is William Stimmel, Stimmel. My professional address is P.O. Box 280, Rutherford, New Jersey.
Madam Chair, I'm offering Mr. Stimmel as an expert in professional planning. He's appeared before this board a number of times recently.
Yes. Yes, we accept
Your license is in good standing, Mr. Stimmel?
Yes, just renewed it.
All right, Mr. Stimmel, why don't you begin by, I'm assuming you want to briefly review the existing and proposed conditions, and then you can go into a discussion of the variances that are being requested.
Sure, just very quickly, the subject property is an irregularly shaped lot with an area of 39,734 square feet. It's 0.91 acres, a little bit less than a full acre. It's occupied by a centrally located 2.5-story, 7,103 square foot single-family dwelling, which has a total of 5 bedrooms. There is a 1-story garage to the northeast of the principal building. The area to the east of the principal building in the rear yard is terraced. Access to the site is proposed by 2 access points which function as a semicircular driveway to the front or west of the building. And the site, as the board members know if they've been out there, is currently under construction. The applicant, in addition to rectifying some of the issues associated with the prior contractors and the work that was done, is proposing to construct a new swimming pool to the southeast of the principal residence. There's an adjoining patio associated with the swimming pool. There's also an expansion of the semicircular driveway across the front of the residence, including widening the branch which extends to the detached garage at the rear of the residence. The applicant is proposing to construct extensive hardscaping and landscaping, and then associated with all of those improvements is the extensive drainage improvements consisting of new inlets, roof leaders, underground piping, and 12 seepage pits. The site is fully located within the RO Mountainside Zone. Single-family dwellings are permitted principal uses in the zone per the Montclair ordinance. Garages are permitted as an accessory use. Swimming pools are permitted as an accessory use. So as far as the use variances are concerned, we are clear on that. The applicant is requesting 3 C variances, and I'm taking this from the April 17th, 2026 Planning Department review. The applicant is requesting a variance for maximum impervious coverage, section 347-20B, parentheses 2, where 35% is permitted, 28% is existing, and 44.1% is proposed. The maximum accessory structure height for that garage, which is existing but wasn't approved at that height, section 347-34A, parentheses 1, where 15 feet is permitted, 15.3 feet is proposed. And then the minimum accessory structure side setback, section 347-38A, parentheses 2, parentheses A, 12 feet is required, 8 feet is proposed. I'm going to discuss those variances separately for a moment. First, the impervious coverage variance. 35% coverage is permitted on the 39,734 square foot lot. That works out to 13,906 square feet. The applicant is proposing coverage of 17,542 square feet. So the proposal is 3,636 square feet over what is permitted. And that increase in coverage is broken up throughout the subject property. There is the pool, the additional patio area, the expanded driveway at the front of the building, and other ancillary improvements, including, but not limited to, a small extension of the building, some additional steps and walkways, retaining walls, equipment pads, and so on. The largest portion of that is the expanded driveway. The driveway is going from 5,184 square feet to 8,016 square feet. So that's an increase of 2,832 square feet. The pool and patio is an additional 1,746 square feet. and then the remaining 1,795 square feet are scattered throughout the remainder of the property. So the increase in coverage is not all concentrated in one area. In conjunction with the analysis of the request for the impervious coverage variance, I think it's important to look at the municipality's concerns in establishing that coverage requirement. What was the purpose of establishing that zoning requirement? And I believe first and most obviously is the stormwater runoff, which Mr. Rigg just spoke about. That runoff is going to be mitigated by the installation of 12 concrete seepage pits installed underneath the rear yard area. Because of the extent of the disturbance on the property, the applicant is not only required to accommodate stormwater runoff associated with the increase in coverage, but reduce it compared to what's existing on the property. So it's not maintaining that level of runoff, they're improving upon it. And that is because of the NJDEP requirements for a major stormwater development. The second consideration with the coverage variance is the impact on the neighbors. And I think the board understands where the work is taking place on the subject property. From my analysis of it, I believe there's going to be a limited impact on the neighbors. That increase in coverage is distributed throughout the site. Aside from the front driveway area, there's limited visibility from the public right-of-way and adjoining properties, both due to the topography of the site. The site drops off sharply from Upper Mountain Avenue to the rear of the property. Based on the location of the principal building, which screens much of the rear yard from the street, and then also the landscape screening around the perimeter. There's extensive evergreens around the both sides and the rear of the property. The third concern with the coverage variance is the aesthetics. Obviously, at the moment, the site is under construction, but when finished, you've seen the plans. It will be an attractive and well-maintained property now and into the future. What the applicant is proposing to do is restore the prior condition of the house and improve the overall aesthetics of the property. And then finally, the fourth requirement, or the fourth issue associated with the coverage requirement, which is the green space or open space. And the applicant does have adequate outdoor space provided for the residents of the house, both with the rear lawn area and the lower portion of the rear yard, the hardscaped areas, as well as the patio. And that goes to the positive criteria, establishing that the benefits in granting the variance outweigh any detriments. I believe that we have successfully addressed the concerns associated with the requirement of the coverage variance. The other side of the coin is the negative criteria. The applicant has to demonstrate that the variance can be granted without substantial detriment to the public good and would not substantially impair the intent and purpose of the zone plan and zoning ordinance. Again, based on my review, I see no substantial detriment. The primary concern from the public welfare approach to the coverage variance is the stormwater runoff, which Mr. Rigg has testified to is going to be addressed and improved upon when compared to the existing conditions. There are a number of technical items from the board engineer's review letter which have to be addressed, but from my evaluation of it, it doesn't appear that there's anything that couldn't be resolved. We're reducing the runoff. There's limited visual impact to the adjoining lots and rights of way. And then as far as the substantial impairment of the zone plan and zoning ordinance, again, I don't see any substantial impairment. This variance request, if granted, would not set a precedent. As the board knows, every application is judged on its own merits. We're talking about this one variance for impervious coverage, which is mitigated by all the reasons I have previously mentioned. The two other variances, the accessory structure height 15 feet is permitted, 15.3 feet is proposed, and the side yard setback to the accessory structure, where 12 feet is required and 8 feet are proposed, are both a result of what has been testified to was a contractor error by the prior contractor on the property. The accessory structure height is really a de minimis situation, as Mr. Trembulac had said. 0.3 feet is 3.6 inches, which is less than the width of my hand, so it's really minimal deviation. The garage structure itself is certainly an attractive building. It's located more than 130 feet back from the roadway. If you're looking at it from the sidewalk along Upper Mountain Avenue, you're standing at an elevation of about 414 feet. The peak of the roof is 415.7 feet, so from your eye height, you're actually above the top of that garage. So it's not overwhelming, certainly from the public right-of-way, and it's well screened from the adjoining properties. As far as the structure side setback, the garage, again, is set back 130 feet from the right-of-way, and the visual impact would be limited to the property to the north. The principal building on the property to the north is approximately 51 feet from the closest point of the garage structure. And again, there's extensive evergreen screening in that area alongside the garage as well. So for all those reasons, I believe that the board has sufficient justification to grant the requested variance relief, both for the impervious coverage, which is proposed as a result of this construction, and the accessory structure height and accessory structure side setback, which result from the prior construction done on the subject property. Thank you.
Okay. No further questions.
Thank you. Mr. Church, do you have any questions for this witness? Mr. Cruz?
I have no questions.
Mr. Griffith?
Has your neighbor on the garage side raised any concerns or questions? And there's according to the drawings, there's a fence there that goes straight back. It looks to be approximately 10, sorry.
There's a fence between the properties. Mr. Hijazi has a row of arborvitaes, and so do the Callahans. So there's 2 rows of arborvitaes and a fence between.
Looking at the drawings, it appears to be approximately 10 feet away from the edge of the garage. Is that about right?
The fence? That's
The
correct.
fence. On the front side and more on the back. It's angled.
Correct.
Thank you. Do you have, let's see, who do I ask this of? I don't think I can ask this of you. Thank you. Thanks. I guess I'll ask this and I'll get corrected. The Historic Preservation Commission noted the suggestion that the front driveway be reduced in size to be more in scale with the property. You have a lot of runoff. It is 28 feet wide. You know, a highway lane is 12 feet, so times 2 would be 24. Do you think it would be reasonable to reduce the width of that drive to 24 feet from 28 feet?
I understand where the question comes from. These types of semicircular driveways are not uncommon in front of, how do I put this, larger stately homes like this one. In terms of what the typical dimension of that driveway is, I don't know. My view of it is that it doesn't seem out of line based on the size of the property and the size of the home. Obviously, the runoff is a concern, but we believe that's been mitigated.
Thank you.
Thank you. Mr. Stimmel, I don't know if this is a question for you, but I'll ask it anyway. If you're looking at the drawing to the right of it, the driveway, it looks like part of the driveway goes up, past the house. What is that for, and is it necessary?
On the south side of the house, the
Yes.
right side, if you're looking
Correct.
from the street?
Yes.
I think it was just intended to park 2 cars there.
Okay, and is that required for the number of bedrooms here, or can all of the cars be parked in the garage and the driveway in front of the garage?
It looks to be a 3-car garage. I don't don't know what it's a 5-bedroom house, so if you have 3 spaces in the garage and 2 on the right-hand side, it's, it doesn't appear to be an excessive number. The ordinance does allow for surface parking of 4 lots, 4 vehicles in addition to the garage, but I could be misreading that.
Zainab, do you know how many parking spots?
For a 5-bedroom house, 3 parking spaces are required.
Okay.
If I could respond to that, Ms. Harris, it's my understanding that the purpose of that is for visitors to be able to pull in off the street and to park here.
Okay. They couldn't park if that's a 3-car parking garage. Would they be able to park in front of the garage?
They would. It's pretty steep here, really steep. So I think this is just like so people who maybe can't handle a steep driveway can get into the house without. That's I think the purpose.
Okay. I have a question for Mr. Riggs, but I will ask the public if they have any questions for Mr. Stimmel.
Well, let me just, Mr. Tremblay, you don't have any further witnesses,
No.
right? So I think the board should ask all their questions first.
Okay.
And then we'll go to questions of Mr. Stimmel and comments at the same time, and then bring it back. for
Okay.
us.
The question for Mr. Riggs.
More important than I am at this time.
It looks like the parking deck from, west to east, there's a probably 8-foot drop right now, is that correct?
Yes.
Not the parking, the pool deck. From that,
Currently, there's, yes, we have an elevation 400 at the corner here, and we have 394 in the back. This will all be at an elevation of 398 when finished.
and so
it'll be
how will you build up the deck in the rear?
We have the one contour going around the back of the pool area, and we graded it down on the upper end. So this is being dropped lower, and that side's being raised up.
And so will you have a wall at the lower side?
There's an existing wall there now. We don't need an additional wall at that location. We can grade it without it.
Okay, so at the east end, that end of the pool is going to be at grade.
Yeah, the elevation is shown as 397 for this. The top of the wall is 394, so it'll be a 3-foot drop from the decking down to the wall.
Okay, so I guess my question is, how are you building up the deck?
It's just with soil. We don't believe we need an additional wall.
Okay, and then are you installing drainage in that built-up area that,
The drainage will be collected and connected into the system.
is it just gravity, or are you piping?
It'll be gravity and piping into the system. There'll end up being a inlets next to the pool area, so that the water will be graded away from the pool. Outside pools, you take the area from the pool and you grade away from it, keeping the leaves and the dirt out of the pool. We'd end up with a drain on this side to collect it and put it into the seepage beds. We could also add the same thing along the back.
Okay, so the inlets that you speak of, they're not shown on the plan currently, right?
Currently, they are not. That's part of the revisions to the drainage system.
Ms. Harris?
Yes.
I might also add, there's a...
Mr. Hart, get near a microphone, okay?
Ms. Harris, the retaining wall shown here also has a foundation drain that runs the full length of the property and ties into the drainage system.
Is that shown on the plan?
It does not
The
appear to be shown
foundation?
on the plan.
No, okay. I think it might be helpful for your neighbor to hear that or see that. Okay, so you would need to add the inlets that you're proposing to this this drainage plan?
We would collect the stormwater from around the pool to ensure it doesn't go towards the neighbor. We can do that with a slot drain on the side or inlets.
Okay.
I mean, I think the stormwater management, which is obviously a big issue with the extent of impervious coverage here, I think the applicant stipulated that they would comply with all applicable major stormwater development regulations, and that would ultimately be subject to review and approval by the township engineer. That's more stringent than the standard condition that we normally put on there. So that if, and I'm just saying if the application's approved, that would certainly be a condition.
Okay. Thank you. Should we open it up to the public for?
Yeah, I think this would now be an opportunity for anyone to ask questions of Mr. Stimmel, and if you have any comments, now is the time. So would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
I do.
State your name and address.
My name is Seth Yellen at 118 North Mountain Avenue in Montclair, New Jersey. Good evening. Thank you for being here late. I reside at 118 North Mountain Avenue in Montclair. I'm the owner of the immediately adjacent downhill property to the applicant's premises at 105 Upper Mountain. I'm here to formally object to the impervious coverage variance sought by the applicant and to respectfully request the board require a full independent stormwater management review of the township engineer before any approval or permitting is granted. I'd like to submit a written objection letter and supporting exhibits for the record, and I have copies for the board.
Okay, now this is a letter written by you.
By me.
Okay, and what we need to do is, you need to read it into the record, okay? Well, what is it? Let's start with that.
It's documenting historic damage that I have incurred on my property from improper management of stormwater in rains, after the stormwater seepage pits have been installed and the retaining wall have been installed, and requesting, documenting the history of the interaction with the property owner and indifference to damage, and asking and seeking formal approval from the board that before any variance, I ask that you have a full township engineer.
Okay, I mean,
review.
you just heard what I said, that, you know, in the event the application is approved, that there would be a full review by the township engineer.
I did.
Okay.
I'd like to enter my testimony into record, though, so that I can at least give you some of the history of
Let me
what's
just see what
occurred
you
here.
want to introduce, first of all.
Certainly.
And are there multiple copies of this?
I have 6 copies.
Okay, give one copy to Mr. Trembulac. Okay, and these are all interactions that you had or statements that you're making now?
That's correct, yes.
Yeah, okay. There's no third party involved in here, okay. It really consists of a May 28 letter, which is 3 or 4 pages, and then a bunch of exhibits.
That is correct, yes.
Okay. I think we'll mark this as 01. And we'll pass out.
Do I need to read it into the record, or can
Well,
I
I think what I would do is I would read the letter part,
Okay.
if you don't mind, yeah, just so it's clear.
Fair enough. I only have 4 copies now. Sorry.
Okay, you can proceed, Mr. Gallen.
Thank you. I'm the, dear members of the Board of Adjustment, I'm the owner of the property located at 118 North Mountain Avenue, immediately adjacent downhill property to the applicant's premises at 105 Upper Mountain Avenue. This objection is submitted in response to the notice of hearing received by the undersigned on May 22nd, submitted by Mr. Trembulac, a copy of which is attached as Exhibit 5. I write to formally object to the variances sought by the applicant and respectfully request that the board require a full independent engineering review before any approval or permitting is granted, and that the board deny the impervious coverage variance in the absence of such review. My property at 118 North Mountain is situated directly to the east, southeast of, and downhill from the applicant's property. The 2 properties share a long north-south border. The applicant's rear yard sits at a higher elevation than my property, and the natural topography causes stormwater from the applicant's property to flow eastward and downhill onto mine. The proposed pool and patio are located in the applicant's rear yard along the shared border, and the precise area most likely to affect drainage onto my property. I have a direct and substantial interest in this application as the neighbor most immediately and foreseeably affected by any increase in the impervious coverage and any inadequacy in stormwater management on the applicant's property. This is not a case of speculative or hypothetical harm. During the summer of 2024, and this is after the stormwater mitigation efforts have been put in place, the applicant conducted extensive excavation work on his property in connection with the improvements now seeking variance approval. That excavated soil was left entirely unsecured and unprotected. No silt fencing, erosion barriers, or sediment control measures were properly employed. During a rainfall event, a significant volume of that soil washed downhill and eastward across my property and directly into my swimming pool, depositing over 3 inches of sediment and rendering the pool completely unusable during the summer. The following documentary evidence of this damage, copies of which are attached to the letter. 7 photographs taken contemporaneously with the damage showing the unsecured excavated soil on the applicant's property with no erosion controls in place, the path of sediment runoff across my lawn, my swimming pool completely filled with sediment-laden brown water. There's a written demand letter sent to the applicant on August 22nd, 2024, documenting the damage and requesting remediation. A professional remediation proposal from the aqueductor for $9,700 to drain, acid wash, and refill the pool, and text message exchanges with the applicant's project manager dated August 22nd and 23rd, in which the project manager acknowledged the silt fence will be maintained, confirming it was not properly maintained prior to the damage, and subsequently reporting that the owner had been personally informed but was, quote, not very receptive. The remediation cost was borne entirely by me. The applicant, having been personally and directly informed of the damage within 24 hours, made a deliberate decision not to respond or contribute to remediation. This history is directly relevant to the board's evaluation of this application, as it establishes that inadequate drainage controls on this property have already caused quantified, documented harm to the adjacent downhill neighbor. As identified in the notice, the applicant seeks to permanently maintain impervious coverage of 44% on his lot against the maximum of 35% permitted in the Montclair Code. This represents a 26% exceedance of the ordinance limit. The 35% maximum exists precisely to ensure that sufficient permeable surface remains on each lot to absorb stormwater on site rather than displacing it onto neighboring properties. The applicant's lot sits uphill and to the west of mine. Every additional square foot of impervious surface, the pool shell and the surrounding patio, is a square foot that no longer absorbs rainfall and instead sheds it eastward and downhill toward my property. I note that the applicant has installed water seepage pits along the eastern edge of his property, adjacent to much of the shared border with my property. The existence of these pits is itself an acknowledgement by the applicant that stormwater management along this border is a real and material concern. However, these seepage pits do not extend the full length of the shared border. At the southern end of the shared property line, the ground contours create a gully that captures and channels water eastward and downhill directly onto my property. This southern section falls outside the area served by the existing seepage infrastructure and represents an unaddressed gap in the applicant's drainage planning. It is precisely in this southern section, the area with the unaddressed gully, outside the coverage of the seepage pits and at the lowest point of the shared border, that the applicant proposes to install the new in-ground swimming pool and attached patio. These are among the most impervious surface additions contemplated by this application. Placing a pool shell and surrounding hardscape directly over and adjacent to an existing drainage channel that already directs water onto my property will predictably and significantly worsen the runoff problem that has already caused me documented harm. I respectfully submit that the board cannot make the required finding on the negative criteria, that this variance will not cause substantial detriment to the public good without first obtaining a comprehensive independent stormwater management analysis from the township engineer. The applicant's own submissions should not be accepted at face value in this regard. This is not a reflection of the quality of any particular submission, but rather a recognition that given the documented history of drainage failures on this property, the demonstrated inadequacy of prior erosion controls, and the specific topographic vulnerability of the adjacent downhill property, independent verification is both warranted and necessary before the board can act with confidence. Specifically, I request that the township engineer be asked to evaluate and certify the following before any approval or permitting proceeds: whether the proposed impervious and coverage of 44.1% combined with the site's existing topography and drainage patterns will result in increased stormwater flow onto adjacent downhill properties, and if so, whether adequate mitigation has been designed and will be installed. Whether the existing seepage pits on the eastern edge of the property provide adequate stormwater retention for the full length of the shared border with 118 North Mountain Avenue, including the southern section where a natural drainage gully currently directs water eastward onto my property. whether the placement of the proposed pool and patio in the southern section of the rear yard adjacent to the existing drainage gully has been adequately accounted for in any stormwater management plan, and whether additional controls are required in that specific area. Whether any stormwater management plan submitted by the applicant demonstrates to the township engineer's satisfaction that all stormwater generated on the property will be retained on site under design storm conditions and will not migrate onto adjacent properties. I note that I'm not addressing any of the other variances here on Section 4. Section 5, the board is asked to rely, at least in part, on representations made by the applicant regarding the adequacy of his stormwater management approach. I respectfully suggest that the documented history of the project counsels against placing unqualified confidence in those representations without independent verification. During the construction phase in 2024, basic erosion and sediment controls required by New Jersey law were not properly maintained. The applicant's own project manager acknowledged in writing that the silt fence will be maintained, a statement that confirms that control was not functioning as required at the time of the damage occurred. The resulting stormwater event caused nearly $10,000 in documented damage to my property. When personally informed of this damage, the applicant chose not to respond or remediate. The applicant subsequently communicated to area neighbors in a manner that reflected a complete indifference to the legitimate concerns of neighboring property owners. None of this is offered to impugn the applicant's character, but rather to make a straightforward point. The record of this project does not support a finding that the applicant's stormwater management representations should be accepted without independent confirmation. The township engineer is the appropriate body to provide that confirmation, and the board should require that review before taking any action on this application. For the foregoing reasons, I respectfully make the following requests: that the board table any decision on the impervious coverage variance pending a full independent stormwater management review by the township engineer, addressing specifically the items identified in Section 3 above, including the adequacy of drainage coverage along the full length of the shared border with 118 North Mountain Avenue, and the impact of the proposed pool and patio on the southern drainage gully. That no permits be issued for any improvements associated with this application until the township's engineer review has been completed and the board has had an opportunity to review its findings. In the alternative, should the board be inclined to approve the impervious coverage variance without a prior engineering review, that approval be conditioned upon A, submission and approval of a comprehensive stormwater management plan certified by a licensed professional engineer, demonstrating that all stormwater will be retained on site and will not flow onto adjacent properties. B, installation of all required drainage infrastructure, including controls addressing the southern drainage gully prior to issuance of any certificate of occupancy. And C, posting of a performance bond or cash escrow in an amount determined by the board's engineer to be maintained for no less than 3 years following completion of all improvements as security against stormwater damage to adjacent downhill properties. Thank you.
Thank you.
Any other members of the public wish to be heard? Would you raise your right hand? Do you swear to tell the truth in the matter pending before the board?
Absolutely.
State your name and address, please.
Richard Heller, 36 Valley Road, Montclair, New Jersey.
You might want to hold the microphone.
Okay. I'd just like to speak in regard to the homeowner at 118. Since the damage occurred at this property.
Before you go any further.
Yeah,
Rich,
are you affiliated with the applicant, or what's your?
I'm actually a representative for the homeowner.
Okay.
I'm on the site every single day.
Okay, hold on. Mr. Trembulak is representing the homeowner. You are whom?
I am a project or site supervisor.
Okay, so you're a site supervisor hired by the applicant?
Yes, sir.
Okay, go ahead.
Since the damage occurred at 118 North Mountain, the stormwater retention system has been reworked. The original contractors put the tanks 1 foot away from each other, 4 foot too deep into the ground. So I'm not surprised that it didn't retain any water. Since then, we followed Bruce Rigg's plan to the full extent. I just wanted to make it clear that the same stormwater retention system that failed is not the same one that we have in place now. We've also went through a great deal of trouble to, since I've been on the project since May of 2025, to mitigate any damage to neighbors. the resident at 122 North Mountain, he was having significant sewer backups. The homeowner at 107 North Mountain is connected into our sewer line that runs through their property. We replaced the entire sewer line all the way down to North Mountain because he called me, that homeowner at 122 North Mountain, and he said our sewer is backing up into his yard. We didn't have any running water. There were no toilets. So that's how we found out that 107 is connected to 105's sewer system. So at no cost to 107 or 122 North Mountain, we replaced the entire sewer line, which involved like tearing down a retaining wall at 122 North Mountain, repaving the driveway to run a new line. When we had a severe storm for like 60 minutes and at the beginning of October of 2025, I documented it with video, all of the water running down through the gully between 105 and 107. The first thing I did is went to the Montclair engineer and asked for approval to rework the stormwater retention system to mitigate damage. And Norberto, he approved us to do that work. That's really all I wanted to add. I just felt there were a few clarifying points that needed to be added. That's all I have.
Just one question. How about the erosion control? What's in place right now?
There's a silt fence all the way around the property.
All right, any questions of Mr. Heller's testimony?
Were you responsible for the site when the damages were done to his swimming pool?
No, sir.
No.
I didn't come on this job until May of 2021.
That was a good answer. Thank you.
Is the silt fences that you put up around the property, is that sufficient to keep the runoff?
It is. The landscaper that we had on the property had a giant pile of dirt there. Because I didn't want the silt fence to fail, we hauled like 40 truckloads of a tandem axle truck out of there. So there's actually not a lot of dirt. It's very close to the grade that it's going to be when the project is completed, like within a foot and a half. So to answer your question, yes, I do believe it's sufficient.
It's sufficient.
No,
Strong.
sufficient for the time.
What is it? What's the silt fence made of?
It's like a nylon material.
Okay. It's black nylon.
Yes.
Okay.
Okay. Thank you very much for your time.
Thank you. Mr. Tremulak, would you?
Yeah, if I can just briefly sum up, and I really want to start with Mr. Yellen's concerns. First of all, I think it's pretty obvious that the issues that he was concerned about with the runoff and the lack of soil control and erosion and difficulties with the project manager. I'm looking at the date. All of that occurred in 2004. And we know in May of 2005, the prior contractor, who was obviously incapable of, completing this project properly and doing the right thing, was replaced by probably the most experienced, most qualified, construction contractor in Montclair, Jack Finn and Company, and Rich Heller came on as the project manager. They've been there for the last year. You've heard Mr. Heller. All of these issues have been addressed. And they resulted, like many other problems here, from the ineptitude of the prior contractor, unfortunately. The homeowner, my client has addressed that, brought in the right people to finish this job. They're obviously professionals, as you've heard them tonight. And then, running throughout Mr. Yellen's comments and his letter repeatedly is a request that the town, that the board make sure there's a thorough independent engineering review, which we all know is going to happen. We welcome it. We expect it. We know how thorough Mr. Hernandez is from the Negley Group. And, we're going to have to comply with whatever he requires in order to get engineering review for this project to proceed. With respect to the the variances, I mean, you've heard the testimony, we're not only mitigating the impact of the additional impervious coverage, but because we have to comply with the requirements for a major development, we're reducing the amount of runoff from what exists today. As Mr. Rigg indicated, there have been and will be improvements. The improvements we're doing will also be positive improvements for the neighbors in terms of controlling the runoff. So you're going to have a better situation than currently exists because of the stringent requirements we have to meet as a major development. As Mr. Stimmel also pointed out, there's really no visibility to a lot of what's on this property because of the slope. I mean, I'm talking about the amount of impervious coverage that's visible from the street or adjoining properties is minimal. What's being done here to this property is going to be a substantial aesthetic improvement to the whole neighborhood. Other improvements to the neighborhood, as I've already mentioned, with respect to better stormwater management and drainage. With respect to the garage, again, we have 3 inches on the garage height, which I think is extremely de minimis, particularly given the slope where the garage is really not visible from the street. And more importantly, not visible from the adjoining neighbor to the north, and that relates to the setback. Look, we had a contractor who was inept. We're hoping the board will agree that the impact to the adjoining neighbor is minimal at best. There's substantial tall arborvitaes on both properties. I was there myself today to see it. That garage is not visible from the adjoining neighbor, and of course the adjoining neighbor to the north is not here to express any concerns. So again, we're kind of asking for mercy from the board to allow this garage to remain in the position it's in, which unfortunately results from an unqualified contractor. We think that the impact is minimal, and that we hope that the board would allow the garage to remain in its current location with its current height. As you've already heard, if we had to reduce the height, it can be done, but again, it's not going to be noticeable to anyone, the additional 3.5 inches or so. For all those reasons, I would ask that the board, approve the variances, subject to what we've already discussed in terms of the engineering review and approval from the engineering department.
Thank you, Mr. Tremulak. I'd like to open up to the board for discussion, starting with Mr. Griffith.
This is a wicked web we have. I am somewhat understanding on the garage variances, but they are variances. The contractor's inept isn't grounds for a variance, and I expect somebody to be giving back to the city or to us with regard to concessions when you're asking. So for instance, the request to reduce the width of the driveway in the front, I'd like to see that accepted.
We would agree to that.
Bear with me.
I'm sorry.
But my recommendation is to have you come back with drawings that more adequately show the elevations and the relationships of the whatever retaining walls you have, which way do the stairs go, up or down? I mean, what you've given us isn't clear. I don't have a clear understanding of where the water's going, what the elevations are, what the slopes are. And given the testimony by Mr. Yellen, I think it's not unreasonable for us to ask for a complete set of documents that shows us clearly what it is you propose. And we're not really, I don't really feel comfortable trusting, no matter how qualified your expert witnesses are, I don't buy their words. I want to see the drawings. So my recommendation is that the drawings be improved to show definitively the elevations, the retaining walls, so that there's no questions asked from us about what do you propose to do, and we can see for our own selves that the runoff is being addressed.
And just so I understand your comments also, you're also requesting that the impervious coverage be reduced, consistent with the HPC recommendation, and maybe to bring it closer to conformity with the ordinance.
Correct, yes.
And that would require then, we'll get an assessment of exactly what the deviation of the variance would be then.
Fair, yes.
Mr. Church? Mr. Cruz?
Yeah, I'm in similar agreement with Mr. Griffith from a stormwater perspective. When the stormwater rules changed in July of 2023, they made dry wells only to be allowed to deal with groundwater recharge, and they were no longer allowed to be used for water quality or water quantity for major development. They're typically used in minor developments because of the cost effectiveness, and it's just a common practice in time. But for a major development, dry wells are not allowed to be used to reduce stormwater flow for the 100, 10, and 2-year storms. So I'm a little bit concerned about the current layout. Now, I can appreciate that the contractor erred in terms of this installation, but even if we were to take a more practical, so let's say that they're just glorified infiltration basins. The infiltration basins still require pre-treatment from the driveway, and I don't see that on the plan either. The 96 to 94 slope of more than 50% on the plan, you know, and I understand it's all on the plan, but just I would want to see a more robust presentation before I could feel comfortable approving this, if anything, because, you know, I'm not sure how well the like higher level audits or reviews work, but like I'm not confident that this would meet the major stormwater requirement for. It would meet it for recharge, but it wouldn't meet it for quality, and it wouldn't meet it for quantity, as I see it presently.
Thank you. I have an issue with the impervious coverage variance request because a lot of it, I think, is the driveway is oversized, right? You've got a very wide driveway. You can, you know, have 2 cars and change park on that circular driveway and still have room. And I don't really understand what the side parking is for when you could, you know, in practice, they're going to park in the circular drive. So I think that the impervious surface can be reduced significantly, and we can evaluate it then. Is there a reason that would, or is there something that would prevent the applicant from presenting this to our engineer for review and comment before they return to us? Because I would like to get comfortable with the engineer's review and approval and recommendations before we approve.
Nothing that would prevent it, no.
Okay.
So
I'm sorry?
there would be nothing preventing the engineer from writing a report.
So just to
on this.
understand the sequence, the applicant would need to revise the plans, reducing the impervious coverage. That would then need to go to the engineer, who would then issue a report to us. Is that what the board wants?
Yeah.
Now, with respect to the height of the garage, there was a request for a de minimis variance. The HPC requested the height be reduced. What's the applicant's position on that? Do they, if you're revising the plans, are you going to eliminate the height variance, or?
It's really up to the board.
What is the board's thought? I mean, if we're going to be revising plans, what's the board's thoughts?
What's it at now, 18?
No, it's at 15.
It's 0.3.
It's like a
0.3
4-inch
is
variance.
4 inches. And it's only because of the finials on the side. It is really, I hate to say it, but it is really minor.
I'm in agreement. That's one area where I think, you know, it's all right.
I
Okay.
generally don't have an issue with the garage variances.
Okay, so they can keep the height as proposed, and the board will rule on the variance.
Correct, yes.
Okay, Mr. Tremblay, you heard what the board's comments were?
And we understand the comments, and, we'll submit revised plans.
So, yeah, I don't think you're coming back in 2 weeks, so when's the next meeting after that?
July,
July 15th?
Okay, you'll consent to an extension of time for the board to act until that date?
yes, we will.
So there's a request to carry the application to July 15, 2026 without further notice. Someone want to make a motion to that effect?
I'll make the motion.
All
All-
in favor?
Aye.
All right, it is carried.
Okay, I want to talk to you, though,
Thank you.
about... Oh, we need a motion to adjourn.
Motion to adjourn.
Thank
I
you,
move.
everyone.
All in favor?
Aye.
Aye.
What they want is they want to see us giving them back some, like reducing the driveway.
Before they'll approve the garage.